Okay. I know it's in Sledge Agreement Updated 2, sent 1:54 p.m. on Wednesday, December 28th.
All right, that's going to be, I think, 455Y.
That is correct. 455Y. And under number 8 in 4.
Sorry, but that is that is 453Y. 455Y was the one that was sent on December 28th at 1:54 p.m.
That's exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455Y.
Right. And I'm not saying it's not in other versions. I just know it's
I
in.
don't know whether it is
Okay.
or not.
I
but
just know
okay.
it's in that one.
All right. And what number was that, please, sir?
It's number 8.
Okay.
So it's number 8 in 455Y. Okay,
Correct. But of course, not number 8 in the final version because it's not in the final.
right.
Okay.
Okay, so you understand what he wants to ask is that, and I don't know what you think that might open the door to or not.
I think
I-
it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stillwell both indicated that they killed Donovan Thomas using this language. We caught that in down bad. And the fact that Mr. Sledge acknowledged being at that condo during that time,
Okay.
if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would offer up. It's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And so
that's
is
not
your
open.
question going to be to Mr. Wright, from however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard. I'm not going to use,
All right, what are you going to ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting
Mhm.
that a
Something
part
different.
of
Yeah.
number 8 on 455Y be removed, and the state
Mhm.
removed it.
Right.
And without getting into contents about what it said, is this something based, and I'm going to get into yours attorney, you get discovery. Is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is. I'm just going to say what you asked to be removed. Is it based on anything he ever said to the police? Is it based on anything that he told to the district attorney or any DA investigators? And I was just going to conclude it and say, Mr. Wright, so the thing that you asked to be removed, it's not a situation where Mr. Wright, Mr. Sledge allegedly said something and was now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that.
Okay.
I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that Mr.
Okay. I
Sledge.
think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously at issue.
Right. And the state is putting it before the jury that Mr. Sledge has disavowed what's been put in front of him, and I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah,
This
I
is-
understand. It's fine for you to ask that question. Do not ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do that.
agree to,
gonna
because
do
then I will let her get into, here's why we said this, okay?
Completely understand.
All right, everybody understand that? That's gonna apply to anybody that might examine Mr. Wright. Okay,
So,
all right, what else?
so Your Honor, once okay, I'm not going to follow up. I'll just redirect if necessary. But number 3, Mr. Wright made a particular statement on cross, I think, as it relates to number 3, or it may have been on direct, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was
It
played.
has.
I think that the content, just number 3 alone from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state, the statement that he makes, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that, not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false. And Mr. Sledge has stated that he feels like it was false. And then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3, so that the jury can fully understand and appreciate what it is that everybody is saying the
Understand.
state refused to change.
I can make this easy. I'll read that number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination, and the jury will get to hear it. I'm fine with that.
And on behalf of Mr.
Okay.
Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't think to that.
Okay.
I think the subject matter of that language is
All
appropriate.
right,
Okay, good. Then that means I can get, okay.
all right, sounds good. Anything else? Okay, let's get Mr. Wright and the jury. And Mr. Adams, you
Your Honor,
can
can
come
we-
on up too.
Can we approach really quickly regarding a witness? Hang on.
Yeah. Hold on the jury. Mr. Wright can come on in.
Testifying, and therefore, I'll be asking you questions, and so we need to get a sense of each other.
Was there a discussion from the state of, did they advise Mr. Sledge of what they would be asking him?
No, there was general questions again, but it was not, often when you think about prep, witness prep, you think, hey, I'm got 20 questions here, the 20 questions on B. It wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection as answered.
Sustained. Mr. Adams, go ahead and just focus in on what it is that, I mean, we're all familiar with what he's already testified to.
At any time after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection
No.
relevance.
Overruled.
No. That was, like I said, we met the one time and then we've appeared for trial. And to be clear, we appeared to trial a couple times, but we weren't called, but they did not ask questions or anything. We just sort of waited.
Mhm.
So again, trial was really the next instance of any communication between the state and my client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No,
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to
Objection
report?
relevance.
Overruled.
no. In fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic.
What I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, I'm not going to ask you about that, do you have a specific recollection of him, of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clear.
Okay.
You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I want to, almost done, just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state
Okay.
in regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th, is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge was good to take the plea, he didn't want any media, and that he just wanted to get back to his family. Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you,
Okay,
sir.
thank you. Mr. Sharp?
Good afternoon, Mr. Wright.
Good afternoon.
Attorney
sir.
Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AS, which was that final. These are just my own little notes.
If you,
This shouldn't be. These are, no, these are all just my own notes. Okay,
I'm just gonna put these in front of you.
sure.
So they're handy. Thank you, Your Honor. Okay. Attorney Wright. On direct examination,
Mhm.
you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several,
Mhm.
but there was one in particular that the state changed for you, correct?
I need you to give me a little more info
Okay.
on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55. Let me, one more time. 6.
State's just handing it to me.
Okay,
When approached.
gotcha.
It is.
Ah,
I believe
it's
it's 455Y.
yes,
Yes.
yes.
Now, we're throwing a lot of numbers at the jurors.
Okay,
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgements, correct?
no,
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
yes,
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
yes,
And you were able to see what your client may have said or did not say to any police officers.
correct,
Okay, and certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
okay,
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
yes,
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it. Okay, you with me?
Yes,
The state removed it, we agree?
yes,
Okay, that part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one
Okay.
of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection asked and answered twice.
Oh,
That's correct.
Thank you. I just want to talk to you about the timeline of you receiving the plea offer and in actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes,
Okay, and that was the day before the plea was entered.
correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street, the Fulton County Jail, to discuss the plea offer with your client,
Yes,
Mr. Sledge. And do you recall how long you met with him that day?
now that I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later, prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes,
Okay, and as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection relevance is to.
I'm
Mr.
discussing
Sledge.
their ability to go over this document.
overruled.
There's a thick glass barrier in between you and Mr. Sledge for this meeting,
correct,
and he's on the other side of the thick glass, correct?
correct,
And of course, you have to talk loud, but you
Yeah.
can hear each other, correct?
correct. And let me at least, so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right?
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time, and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay,
But
so
I just wanted to point out that, yes, we can talk as well as hand stuff to each other
okay.
to review.
Well, let's let the jury know what we're talking about here.
Yeah.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass through in those
Correct.
booths.
We
Okay.
can, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
All right. Could you refer to 1AS
Okay.
for me?
I have it, sir.
Okay, thank you. You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes,
And he was facing 15 years to serve. Excuse me. He was sentenced, the agreement was 15 years to serve on probation, correct?
correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld
Yes,
and would be dismissed if he fulfilled the agreement.
yes,
Okay. At this point, sentencing is still withheld, correct?
correct.
And the maximum he's facing on count.
All right, y'all come on up, please. And Miss, up to the podium, one of you can come on up and the other one can just sit in one of those seats right there till it's your turn. So you are Miss Borden?
Yes. Your Honor.
Okay. And you want to, what, live stream or what you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right? Okay.
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You
Okay.
certainly may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes kind of a security matter and a distraction to the deputies and frankly to me to have to trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, you know, we've already kind of got everything set up. There are 2 different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader and also an awarded community advocate where a former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now.
Right.
That I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either gonna be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 25 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay?
Okay.
All right. All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Ms. Hall. Good morning. How are
Good
you?
morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and
Yes, ma'am.
audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which I
Right.
have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm affording, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I
pool
can pull,
sources
yeah, I can pull
already.
audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're gonna need to be wherever it is that the deputies put you,
Yes,
and
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating?
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were gonna be the one covering court?
Is it granted?
Yes.
Okay,
We'll get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right, does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today
to the podium. One of you can come on up and the other one can just sit in one of those seats right there till it's your turn. So you are Ms. Borden?
Yes. Your Honor.
Okay. And you want to, what, live stream or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right?
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You
If I
certainly
can.
may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes kind of a security matter and a distraction to the deputies and frankly to me to have to keep trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, you know, we've already kind of got everything set up. There are two different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the World 2022, and I've been doing this over a decade as a civil rights leader and also an awarded community advocate for our former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now
Right.
that I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either gonna be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 2-5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay?
Okay.
All right. All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Ms. Hall. Good morning. How are
Good
you?
morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and
Yes, ma'am.
audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which I
Right.
have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm supporting, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I can
pool
pull, yeah, I can
sources
pull
already.
audio from pool.
Okay. And what what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're gonna need to be wherever it is that the deputies put you,
Yes,
and
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating?
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were gonna be the one covering court?
Is it granted?
Yes.
Okay,
We'll
thank
get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right, does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today.
Provide me with anything you found between yourself and any of the attorneys for co-defendants who have entered pleas.
Judge, the court gave me until noon. And
Oh, okay, that's fine.
Your Honor, I would like, with permission of the court, to check with Ms. Winfrey's exhibits to see that 460 is up there, because I took one stack, but
Okay.
460 was not.
You can check.
Thank you.
And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor, we haven't discussed that.
Y'all haven't what?
We haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any sort of an agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
Yes, Your Honor. And may I inquire, with the court inquire, whether 460, which was a document that I believe at the end of the day,
Mm.
some counsel for defense was looking at, I believe that I retrieved it, but I believe Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
Now, there was several documents that someone, I think it was either myself or Mr. Adams, put into the documents that folder for the documents.
Identified only.
Yes, identified only, I don't know.
Yes. All right. Do you locate it? Were you able to locate it, Ms. Love? Okay. Well, I'd imagine that would be easy enough to reproduce. It was just printouts from emails, right?
It was Wright's emails.
I mean, yeah,
Actually,
I'm sure I have a copy of it since you gave it to me, if that would help.
it would, if the court doesn't mind allowing us that copy, court's copy, I would.
Okay.
Return it back.
I don't think I've made any markings. Well, I have made a marking on it, sorry.
It would actually help us to recreate,
To just, yeah, look at it to recreate it, that's fine.
Thank you. Thank you very much. Thank you.
Nobody was able to find a 460Y anywhere?
I personally don't have.
Okay. Has anybody checked up in that home area? Okay. All right, well, it can be reproduced. It's not the end of the world if we can't find that particular one. All right, turning to the issues we need to decide. Ms. Abbasi, your co-counsel, had filed a motion in limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
Yes, Your Honor.
All right. And Ms. Abbasi, do you want to make any argument?
At this point, no, Judge, the motion is largely self-explanatory.
All right.
I'll let Ms. Sullivan.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, when we get to presenting this act, which is count one, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of
Right.
Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi
All right.
through the
Well,
lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos that we intend to
all right,
introduce.
let's see what they are.
And I can bring them up to the court. For the purpose of this hearing. Yes. And for the purpose of this hearing, Your Honor, the state's gonna label them states 1 RR, states 2 RR, and states 3 RR.
And what do y'all plan to present with regard to, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock, then we believe ambushed Mr. Holmes along with two other victims. They were in a vehicle. Mr. Holmes was shot and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, or excuse me, social media postings regarding YSL, very close in time to the murder of Mr. Holmes, Your Honor.
All right, and how many witnesses are you going to utilize?
For that act, so we have 5 witnesses.
Who are they? And what will they generally testify to?
You know, that 5 is a marked reduction from the original list of witnesses. We did not intend to retry that murder.
Well, that's good to hear.
Your Honor, 5, the witnesses for that act are Ms. Sharon Latners, Starry Holmes, who's the mother of Mr. Holmes, Mariah.
An eyewitness?
No, she is, just would be able to bring in his in-life photo.
Let's
And
figure
it's
out a
talking
different
about
way
Mr.
to do
Holmes.
that, especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
I have a relevant objection on that.
And that would be sustained.
And to talk about his involvement, who he is as a, prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah Smith was someone, I believe he had just met recently, who helped set up the robbery that ultimately led to his death.
Okay, all right, have you moved on to another witness now? Is Mariah Smith another witness or?
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't, I don't believe she really knew Mr. Holmes.
How old was he?
substantially. He was 15 at the time of his death.
Mm-hmm.
Um,
And
Yes.
Ms. Latner's backing up, she would, what, introduce a 911 call?
Yes.
And what's that gonna say?
But it was the initial reporting of the shooting. So it was at the time, the time of the shooting.
Just
framing
one
the date.
call?
I believe just one call. Your Honor.
Judge, we would have no objection to the call.
Okay.
Admitted where, the witness says he'd like to speak with police and police don't speak. We have no problem with that call coming in.
Is that the call?
I don't think that that's the call. I think that the initial call about the shooting.
It may be a different call.
Yeah.
It's a different call.
Okay.
And-
Okay, so,
The witnesses are our skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So we're trying to put in.
well, I mean, sure, the fact of the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had
Okay.
these witnesses.
All right, I don't
represent
need to
one of-
hear what it was gonna be at one point in time. Maria Smith is going to say what?
She was one of the 2 young ladies who lured Mr. Holmes and his 3 friends back
Okay.
to the location, or to the location.
All right,
Then we have one of the 2 other victims. We don't plan on calling both of them.
okay,
So that it'd be either Mr. Uten or Mr. Mitchell.
all right,
Then we have the lead detective on the case, who is Detective Hogan. Then we have Mr. Mike Sprinkle, he further brought, did the
He'll-
additional evidence of some of the social
Social
media
media.
that came in later. And then last, sort of,
So 7, not 5.
so Rooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what will prove the actual act, but that's why he's included.
And Your Honor, we do need clarification whether it's going to be Mr. Hooton or Mr. Mitchell. We've been in contact with the state about going through the evidence we've offered for these witnesses, what does or does not need to be redacted. Mr. Hooton's interview is maybe about.
Can y'all spell that last name?
Yes, Your Honor, it's OOTEN.
Okay.
His interview is maybe about 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Okay. When are we going to get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October,
Okay, so fairly soon.
fairly soon. Yes,
All
Your
right,
Honor.
when will y'all know who it's going to be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Well, 2 weeks from now is the end of October, so. I mean, the end of September, trying to rush that along.
We do want to have an opportunity to go through the state what evidence they believe will actually be admissible. Right
Okay.
now, we've got more than 50 pages of Instagram reference from Mr. Blaylock, co-defendant who's not testifying, more than 200 pages from Mr. Ryan. Those are obviously issues we'd rather not sit down with the court and go page by page, but if we need to, then we will.
And Your Honor, I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. D. Williams.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our email if you want.
Can y'all,
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Abbasi or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
all right, well, try to, in a timely manner, please. Okay, let me see the photos. And the photos would come in through the detective. Did you get copies too, or are we just? Is this third one like post-incision, or is that the exit wound?
That is the entrance wound. Your Honor.
Entrance wound?
Yes, Your Honor.
Your Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the lead detective is qualified to explain what type of injury you're going to get. We don't believe the detective will be able to lay the foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim, that he was it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which
Before it's shaved.
before it's shaved, I believe that he could talk about where the bullet was, or that he was shot in the head. And then the last photo, I'm not sure if he'll be able to say it's an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not
Do you think that there's any chance he was present during the autopsy?
sometimes they are. Sometimes they are. I'm not saying that he would, but sometimes they are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so. I believe so, but I need to ask Ms.
Okay, well, you'll,
Ms. Love.
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady, and ambulance 571 was pronounced dead at Grady at 6:10.
Okay, so if he was at the scene, he wouldn't have seen the victim at the scene, so that wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
All
a
right,
limited purpose.
why don't y'all get together? I'm gonna hand these back for now and come up, maybe you could come up with all sorts of stipulations. So we'll revisit that.
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Thought so. Okay. Yes.
On that, I'm not saying I cannot find my list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-80322. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so that we don't go into it.
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea. So it's not a statement that the
It's any judgment of previous conviction is what 22 covers.
okay.
So
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So,
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully. So the certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented, that the jury takes as evidence, are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act. It seems, Your Honor, as well that while the court can't hear us, it seems that while the court can't pick us up, somehow or another, the person who is running the camera, he hears all of our.
All right, well,
He's asking
that
us
is
to turn it
irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
You're-
That is irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear.
I know.
I mean, I'm not worried about how the media can or cannot hear.
I know.
I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
you're-
Because the issue was they could hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all gonna need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
We just get the feed from the courthouse.
Okay, well, then you're not gonna be able to just, to do the audio if it's picking up attorney work product conversations between the counsel at the tables. I don't know what to, I mean, some adjustment's gonna need to be made.
You inquire whether.
I doubt if they can hear it all the way over there, but what all's getting picked up?
Just when they were having a conversation.
The state,
I turned the audio off. But I heard it. Whenever I hear this stuff.
well, I appreciate that, but I'd imagine it's gonna be pretty constant that they're gonna need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversations at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention. Where's your feed, like your audio feed coming from? Where's it getting picked up from? Do you know where the mic is?
No, it's connected to the court system. So whatever feed you are being arrested.
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on Zoom, I assume. Maybe I should text her too or email her too. Instant message her on my computer. Give me just a second. So you're attached to what, the Zoom?
Whatever feed the court gives.
I don't know what feed the court gets, but all right.
Ironic when the court came here.
All right, Ms. Pursfield's reaching out to IT about it now. All right, do we want to turn to where we left off when we were last here, which was trying to sort out the nested hearsay in one of the wiretap conversations?
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions.
Mhm.
And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
We, oh,
Go ahead.
we are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like you do intend to introduce a certified copy of the conviction,
Yes, sure.
and that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would introduce.
And that would be admissible against everybody charged with the RICO. Then they would present facts which they would hope to for that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Good morning, brothers and sisters. Hope you're doing well. I had to hear that again. Like, what in the world did I just hear? Did she just ask if Brother Ryan, Lil Rod right there, is charged with the RICO? She's asking if somebody that's a defendant in this room is charged with RICO? Yeah, I had to hear that again.
He's charged with the RICO count, right?
He is.
Okay. And then charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to
Wow.
be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would introduce.
And that would be admissible against everybody charged with the RICO count.
We would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it and what connection we believe it has to YSL and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on trial now.
Okay.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment. It's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
Fact of
conviction.
Conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overact, which as an
Only
element.
as to Mr. Ryan
Well,
is what they're saying.
well, no, they just said it against everyone as far as count one to RICO.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood the case law as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of
Okay,
guilty.
he
This-
was found guilty. It's still a judgment of conviction.
Well, it's not a final
And-
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay, well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a jury, a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count one. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I think we have some case law that addresses that subject. I'd like to flesh it out, given Mr. Sharp's objection, but I'd preliminarily point the court to United States versus Pelullo, Pelullo, 14 F3rd 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent RICO trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder, who can accept or reject such evidence as it deems appropriate. also United States versus Tocco, Tocco, 200 F3rd 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate. Here it says because the evidence was not used as collateral estoppel, but again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we would point to as a starting point.
All right. Well, we're gonna have to get that sorted out fairly quickly if we think that within the next 2 weeks, we're gonna get to this,
Yes, yes.
or so, 2 weeks or so. Okay. So, Mr. Shar, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
All right, we ready to turn to that Garlington wiretap? Hmm? Oh, yeah, I'm not deciding that issue right now. We'll come back to that. Sure. Evidence before the Garlington wiretap evidence? Okay, then maybe we need to set aside the Garlington wiretap and deal with the evidence that's gonna come in against Ryan. Okay. We'll wait till he gets back, but just trying to figure out which thing to turn to next. Okay, that's fine. Let's take a quick break for anybody that needs to run to the restroom. Maybe we should turn to the evidence that's gonna come in on Mr. Ryan's, on that. That'll happen before the wiretap evidence.
Yes, Ryan, I thought, are you talking about the email that Miss D. Williams sent?
I don't know.
Because
Did she send one recently?
I thought Ms. Abbasi and I, that was what we talked about a few moments ago. You said, the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the
Okay.
court's time to do that.
So I guess it was, yes, Ms. DeWilliams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
Okay,
I'll
so
get with
y'all
Ms.
will get
Abbasi.
together on that.
yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible? Or no?
we can't use it.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder. All right, so do we want to do,
We could talk about the busing stabbing.
the what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. indictment is all in there. However, something which after indictment certainly could be part and parcel and inextricably intertwined in the same facts and circumstances, but that's not this case. So the brief does put out in there that the intrinsic facts that the seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks ago.
Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do, and
Did y'all file a response?
No, we made an argument that essentially is the same one we're going to make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that the case law does say the acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues. I mean, if it's gonna be, they're not precluded just because they're post-indictment, but if they're gonna be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of it. So in as much as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
I like that. I don't think there is a focus. I've never heard them say which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard them say which of those three it specifically are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation, power, etc. of the enterprise with acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial, or at least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself was.
Hear all of this argument, be great under 404B. I'm waiting to hear which of these three categories it falls into. We're talking about two different issues here. Which of the three, and then 404.
It is not 404B, it is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to,
Right.
even if I rule against you on the intrinsic.
Well, if the court ruled against us, it would be a different argument that we'd be prepared to make on a different day, because that's not something we were putting before this court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when Ms. Abbasi asserts that they're not necessary to complete the story of the crime, this is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing, to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that, I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 465, RR for rebellious crime.
All right.
Your Honor, I guess I'm kind of more confused now, because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime. Their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. It doesn't matter whether the gang is continuing.
All right, but the state can prove, if it chooses,
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime, and I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are not guilty of count 1 in terms of definition of overt act of count one. So it would go to prove count one as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but under 402, because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do you have the Zoom up here? Let me pull it up and put it on the Zoom. Considering it's coming, just, we can't, we're not in yet.
All right. Ms. Adasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral and naturally part of what happened. I didn't cite the Murphy.
Okay, well, maybe it was just one I.
I did want to touch on one thing the state said, because I think we're getting into dangerous territory. The state said that this act in and of itself could constitute an overt act to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not in the indictment.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some point.
Still waiting on that law.
No, we actually, I think at some point, and I might be wrong about this, but a contrary position was presented, and whatever case was cited, did not support that position. And we have affirmative, case law that we present in the form of a brief to the court.
All right, well, you go ahead and get that filed can you get it filed? When can you get it filed? By Monday? By Friday? All right, by Monday.
Your Honor, I can get to the court kind of the contrary case law that in the appellate, I know it sounds kind of, doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on acts which were not.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding. Because I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this situation, this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that part is easily
All right,
addressed.
so that'll be 2 different issues. Can an overt act that's not listed in the indictment be the basis, the sole basis to support the conviction?
Mhm.
But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, whether we number them or whatever, I just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay.
Judge, would this
So-
issue
I'm sorry, Mr. Boston.
Hmm?
I don't know if we made it to the 403 part on this.
No, we hadn't. We sort of got sidetracked,
I wanna
but.
make sure I'm not.
All right.
All right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately and.
I think that
I agree, but.
will, and to make certain that we present clearly to the juror, to the court, we
Uh-huh.
do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as to one unanimously has to, deal with the others.
I know, I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find two overt acts?
One.
One of which needs to,
One.
or happen within the statute of limitations?
We agree they have to at least find one
Okay.
that happened within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66, whatever that is.
I believe it's safest that they find
Okay,
unanimously.
okay. All right,
And
then I don't
we-
need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
The intrinsic.
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one.
Mhm.
And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses, and there is an or, so it does not have to
Right.
be all
Could be any
three.
of them.
So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes, they will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary, show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street jail, and to protect one another, to show that you don't mess with one of our own. The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that the
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
that the gang itself conducts itself in a particular way, and in Johnson versus State, a Supreme Court of Georgia case whose site is 312 Georgia 481, decided September 21st, 2021 at Penn site 491. The court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members, are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street Jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street Jail. In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with Blood Gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory for these reasons. We believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person whose connection, we believe, with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect the dominance and the members of the enterprise and the gang itself. So the court found that even though the state didn't charge appellant in connection with the shooting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has here, Influenced and Corrupt Organizations Act, by participating in YSL through these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with a conspiracy. Evidence of Eppinger being charged with the shooting of an officer, evidence that Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here, and that Demise McMullen is a named co-defendant on the 2015 murder in the same indictment.
And brothers and sisters, this is part of the problem here. We do appreciate you joining us. But, you know, just the power of this RICO thing, man, just absolute madness. It's absolute madness. Just joining people together. And, you know, you look at a normal case, you say, okay, well, this one person did something and that's just on them. That's not what this is. The guy way over there did something, but that attaches to that other thing, that attaches to this other thing that creates the pattern. And since we're all together, and since this is RICO, then I may not be guilty of count number 937, but count number 1, the RICO, you still stick me with it. So I'm going to prison on the RICO regardless, because of that and that and that over there and that over there and then that other thing. Oh yeah, and then that from that dude and then that dude over there. So the state is in such a high position to be able to connect these dots, even loosely, it would appear. Yeah, that RICO thing is a monster, baby. It's a monster. What do you think?
Shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of satisfies the requirements of being an intrinsic act.
Okay, which of the three?
The third one, we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge. It should read the charged offense, right? I mean, it needs to be inextricable, right?
Yes, that the
Just a
case is
typo.
citing it wrong. Yes, thank you.
So-
And that being count 1, the conspiracy.
So how is it, and you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count 1, and that it is gang activity, which it is.
All right, I'm not quite sure where I got this language, but I jotted down, and I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense. is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody
So,
know if that's
So this-
as to, that's the explanation for what it means to be inextricably intertwined.
I think that came from Murphy.
That's Williams versus State, 302 Georgia, 474. Cited in the brief.
What year is it was Williams?
2017, it's cited to on the 11th circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if that's what it means for it to be inextricably intertwined with the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed, and we have evidence of what has occurred to further that conspiracy.
So would this be a witness who's being presented regardless, or is this a witness as to, I mean, obviously, if they're just coming in to testify about what happened in the jail, that wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there gonna be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of RICO without telling the jury about the stabbing?
No, we're not saying that. We're not
Okay.
saying that at all.
So then
No.
it's not inextricably intertwined.
But it does, it's an uncharged offense. That arises out of the same transaction or series of transactions as the charged offense of count one. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does
And
this
then-
arise out of that transaction?
The series of transactions, one of them is that the series of transaction is the set of actions that occur after, before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Woody Lee posting, I'm sorry, we made you a thug, so early Lil Thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I
are
just
alleged?
named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun,
Yeah.
did that. It's
All
more
right, remind me
broad.
when the jail stabbing occurred.
It was February the, what date? February 20.
Of,
February the 1st. January the 1st of 31st of 2023.
January 31st, 2023,
Yes.
and he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blaylock, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together in.
Roughly. Okay.
Thank you.
Approximately.
Okay, that's, I mean, approximate is fine.
And also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule. And I'm also curious about how the court will see or not see this position that I'm offering. But under 24-1-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-1-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right, well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
So, okay, see, I knew.
Okay, so that takes care of that one.
All right.
All right, do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Atkins is shaking his head, yes.
Since
You
he
can
is-
look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts, is the court speaking that
Similar set of
specific
facts.
as to, somebody jumping somebody?
Well, I mean, yeah, ideally, if you could get that, that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or RICO, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving Wyfan Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area and they are once more off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving YFN Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay. I mean, I honestly think the 403 argument is easier than whether this is intrinsic, but yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Ms. Abasi, should I let her go first and sit down and see the floor? Does the court want to hear from the state?
It's in the brief, so I'll let you begin.
Well, I mean,
They have the burden. I'll give you the.
all you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it's that it has to survive the balancing.
Okay, well, that's pretty clear.
To exclude what is a scan or cumulative over force, I think everything in here we're dealing with is scan and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are not necessary. I'm sorry. Is that on? That in the 403 analysis, the court should determine the prosecutorial lead, degree of similarity, and temporal remoteness. There are 191 overt acts. I think by the time jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate, examples of criminal street gang activity, already quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There's plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment.
Well,
They heard this.
that's a lot lower standard.
It is, but if even that lower standard, it was met there, then I don't see how it suddenly become necessary here.
Okay. Go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence the state who bears this very high burden. I'm sure we'll hear told over and over again in closing arguments that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia RICO statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are
Up one piece to ensure that
This is where we get pretty deep right here, baby. She's saying it.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence, the state who bears this very high burden, I'm sure we'll hear told over and over again in closing arguments, that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate
The state has 150 ways to prove. Of course, she's making an example, but that's the strength of this RICO stuff. This is what we're talking about, baby. And this is why they can be so sloppy and they still might get away with this. Because there are so many ways that they can connect all this stuff. It's dirty, baby. It's dirty. Look at it. I mean, just listen to what she's saying. It's like, hey, I mean, we got so many ways from Sunday we can do this. We're not even worried. Wow.
the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia RICO statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
To assert their
s-
dominance.
assert the dominance of YSL.
Okay. Since an overact does not have to be a crime, I'll just name them, of course. So number 9, where defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're gonna do something. I mean actual assaults on people.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right, so
Mr.
I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes.
And that's
it's-
overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were
Okay.
associates.
Your Honor,
Mhm.
I'm sorry, I'm just trying to
69.
I'm trying
determine
to
what you're
figure-
asking. Are you asking what the indictment alleges?
What,
Is-
yeah, overt acts.
Well, the
alleged
indictment,
in the
as I
indictment.
understand it, just broadly alleges that the overacts are done to that for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overacts are designed to do what. So the answer, as far as I understand your question would be all of them. They've
All right,
alleged
well,
all of them.
but I mean, I'm asking the state sort of what, I, I appreciate that position, but I think I mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was over act number 79.
All right.
Also, the act on for 28. By Mr. McMullen.
Overt act number
April 20,
28?
April
Oh,
28th.
okay, yeah.
Yes, I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know
acts
what the state's position is.
that were done to acts of violence done to promote either the
Either
notoriety or to
protect
protect.
the members of YSL or to promote the dominance of YSL.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of Mr. by Mr. Murphy. On April the 12th.
Do you
Jackson
have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where there's.
Is she trying to make a movie? What kind of question is that? What is Paige talking about?
Do you
Jackson
have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because?
Jackson
have any
What
other
is
overt
going on? What did this chick just ask? What? Are you bored? Hey, you got somebody getting beat down? We need to watch a video today. We ain't got nothing else to do. We just want to look busy. So, slide me that video. I want to see somebody get beat down. What is going on? What's wrong with you? Love is like, I don't know about no beat downs. I don't know if we got that on the menu. We kind of sold out of beat downs. We got some murders for you, though. You want some of those? What is this? Oh, man. Oh, man. Off the rails again. Wow.
acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where they're shooting at other members, and we
Okay.
have where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is. It is.
Okay.
Where also I think we have.
And of course, you know where we are. You know we are. All this also demonstrates things that should have already been known prior to her making all the various rulings she's been making without the depth of understanding, right? She's asking foundational questions to things that have been put in writing a long time ago by the state. Because remember, she used to cut people off quick. I can read. Well, if it's I can read. Don't need to explain nothing, right? Because she gonna read it all. Okay. How's your comprehension? You're asking about overt acts and how it connects and who's who and what's what. I mean, I can read. Okay. And now you hunting for videos. Do what? What you doing with them videos, Paige? They ain't helping you stand up for the jury. I know that. So what you doing with the videos? What you doing with the videos, girl? Come on, you can tell me. You can tell me.
And they are, I think, Acts 41 through 45 is the murder.
Okay.
This is the murder
All right.
on the 28th that or the aggravated assault that I talked about.
Okay. All right, well, y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is the
I know
court,
y'all want a decision, but
that's so,
we're gonna come back to it yet again.
and Your Honor, in terms of the number of acts that we've enumerated in here, does the court want specifics or just the number?
Yeah, that's right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances.
That's even more ridiculous. I like my example better. Shucks. If you're trying to say, going back to that cumulative argument, that's way off base. You making my little joke sound credible. Golly. So okay, let's step up to whatever level she thinks she's on. So if I have an instance where there's a beat down, and then you ask me a question like that, and I say, well, yeah, on Wednesday, these other cats from such and such and such and such beat down those other cats from such and such and such, and these cats that are in this room allegedly were involved with that. Oh, no, you can't bring that in because that's another beat down. That's cumulative. You can't have two beat downs. Oh, that, like I said, you better stick with my joke about what you trying to do with these videos. Because if you're trying to be serious that they can't bring in more than one beat down because it's cumulative, because I don't think that's making the streets safer. Hey dog, they can only convict us for one because Paige, if you get Paige as your judge, yeah man, hey, we could beat down 10 different people 10 different days. She only gonna let one get in. The other 9, she gonna be like, that's cumulative, dog. It didn't even matter. Yeah, like I said, that's corny. Well,
Judge,
she is what she is.
The defendants
Justice for
on
you.
a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one, from openings throughout up to even now. The assertion by every defendant is, and even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that this is just me. I'm a criminal, but they aren't.
Okay.
So to the extent that there's no one here willing to stipulate that crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right, thank you.
Your Honor, I'm just looking here at some case law on prosecutorial lead to see what I have to answer Your Honor's question in that respect. It's in 403 itself, in case law, kind of more specific. I'm going to keep looking. I'm looking as I am speaking here. As far as the prosecutorial need, I'm looking at cases where the need is there's no other source for that information, or at least limited sources of that information. I'm not sure how many hours of gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point for, on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case laws specify if we have a level or a test for what need is.
All right, thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, if you want to file it as a brief, that's also fine, but.
What I've got, just looking at some case notes here, prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case Kirby versus State, 304 Georgia at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306 Georgia, 69 from 2019.
All right.
And Your Honor, could we get clarification? Is that a 404B case or a 414 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under 403.
As I said, I've not read the full case. It is
Yeah,
just-
I mean, it's fine. I understand the concept. Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot wearing a chain and it saying some things. BB maybe and Eppinger, some about robbing Smith. What was that about?
Yes, Your Honor, I believe that Mr. Shard, we were supposed to narrow
It
down
was-
what video
yeah.
the state we were going
Okay.
to admit. I sent that over a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week, which I feel like has been a while ago now.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought. So and that, I guess that was with regard to counts 27 through 29, maybe, is I think what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury?
Portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. BB, the two people alleged to have committed this armed robbery,
Right.
on the phone, and a portion of that video, Mr. Eppinger appears in I think it's like an Instagram picture, an Instagram video, and BB shows him the chain. But there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email. August 23rd at about 1:55 p.m.
Bless you.
Sent are approximately 5 clips that probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hillen?
Yes, sir.
Okay, so in all honesty, we haven't had a group this is all acts involving someone that's not sitting here. And if we could have a couple minutes
Okay.
just to talk as a group to figure out
You may.
what our stance is. on
All right,
this.
and you know what? I may have y'all do that over the lunch hour. So the next thing I had us circling back on was, and I guess maybe these were from I don't know, we were going through maybe one of the sets of statements, because I've got like page 2, 523, 513. Oh, these were the wiretaps, maybe. Big Nick.
Yeah.
Waters Road. And then, oh, the comment about, yeah, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said y'all were gonna narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was there were 2 reference numbers. One of them was 513, one of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and there was a non-hearsay purpose for it. Did did y'all ever go back and do that?
By lunch, we can.
Okay.
We'll be able to have an answer by lunchtime.
Yes.
Would you kindly just repeat the 2 reference numbers?
Yes, 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time. and somebody was gonna provide law on that.
Did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overacts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, you'd like to sort of address it?
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy. Listened to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue, so that is admissible. That was about as far as we had gotten. And then, of course, we still need to circle back on the that one that we got bogged down with the nested hearsay with Garlington talking to Funk, who talked to Quay, who talked to Rel. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? Yeah. It's not noon yet. It's about 1:45 but. All right, are you gonna email it or bring it as a hard copy or what's? I'll email it, that makes it quicker. Okay, all right, please do that over the lunch break. Let's reconvene at 1:15.
Yes, Your Honor, and I also put 460 on top of
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you. Thanks.
All right, brothers and sisters. Trying to do this lunch thing. 1:15 EST is the projected return time. How's that sound for you? Does that work for you? Well, if it works for you, then I guess we can do that. We'll come back around 1:15. Hey, that could work, huh? Yeah. One of those days, just hanging out, chilling. You want to hear some upbeat music or some relaxing music? Upbeat, yeah, I figured you want the upbeat. All right, we'll hook you up during lunch. Get some funky tunes going for you. That's a pretty long break. She realizes that, they really don't know what to do. She's trying to fill time. I mean, there's stuff to do, but again, cat's not prepared. What you gonna do, right? Pretty ridiculous. So yeah, what do you say? Well, let's just change the mix here. That's what I'll do for you. Change the mix right quick. Hit you with some of this. Funky tracks. All right, brothers and sisters, we'll check back with you. Have a good lunch. We look forward to grooving with you soon. Might even talk about last night's debate. Well, I called it. But you gotta look at it right. You gotta look at it right. And we might talk about it. Appreciate you being here. Lunch break. Catch up with you on the flip side.
to remember to turn it off again when you leave. Which maybe it's just gonna be an issue at breaks. I don't know, but I don't know. Just, I guess, try to turn it on and turn it off as you arrive and leave the podium area. All right, Miss Love, I appreciate you sending electronically the communications between the state and the various attorneys whose clients have pled. However, I think for me, it's just going to be easier if you can print them out and give me a hard copy, and I'll give you until, if you can just have those to me by Monday morning, that'll be fine. But I just think it's just gonna be easier for me that way. And just, and I didn't go through all of them. I started going through them, but make sure that if there were a couple of emails that, and it was like well into the string. So I'm sure if I got to the original email, the attachment would be there, but just make sure I've got the relevant attachment too. Okay, so I'll just deal with all of that after you give it to me in hard copy form on Monday. All right. Did y'all get an opportunity to try to come to any sort of an agreement, if there is any, on those items 451Y through, I think it was 455 or so, and then 460Y?
Your Honor, it was not an intentional disobeying of the court's instruction. What I was doing was the state's position is slightly different than it was with an argument for why.
Okay.
And whenever the court allows, I'll address it. If he wants me to start now, I'll just start now.
All right, so did you give a redacted copy to the defense, or you just think whatever your new position is might change everything?
It will change everything. And,
all right.
and I did also, the thing that I'd asked Ms. Winfrey for that she so kindly provided was what exactly the objections were to the exhibit so that I could address them in turn. What I recall specifically, I believe that it was Mr. Stillwell who made the initial objection that—
Hang on a second. Can y'all try to be a little more quiet over there so I can hear? I don't know who it is, but, oh, that actually reminds me too, before we get into that, just a reminder to everybody that there's not supposed to be any eating in court, and that the defendants are not supposed to be on laptops. Okay, that has not changed since I took over this case. All right, go ahead.
My recollection is that Mr. Stillwell's attorney is the one, Mr. Sharp, who originally specified a portion of one of the exhibits that he felt should not be allowed or presented to the jury because it contained information he thought was overly prejudicial. If I'm not speaking correctly, I'm certain he'll correct me where I'm wrong. But other than that, I was wanting to make certain I heard all of the objections so that I could speak to them. But if my because I'm going to make a proper to the court.
Okay, it would be a lot easier, I think. Part of their position had been, until we know what the state's actually proposing as the redacted exhibit, it's hard to make objections. So are you ready to share that?
Yes.
Okay.
Yes, I'm ready to address
If you would
it.
do that, that might help the
So, Your Honor,
court and the—
on what theory the state would be seeking to admit out-of-court statements?
That was
Stop.
part of what I intended to address. So
Okay,
I'll just
well,
start.
let's all get a copy of what it is we're—
They're not redacted. It's the ones we gave them. So the ones that I have previously identified
Can I have a hard copy of them? Because that's another one of those things that if I'm having a look on the electronic, it's like embedded within several emails.
Yes.
Before I ever get to what I'm supposed to be looking at.
Yes, Judge. So
Thank
what
you.
What I'm gonna do is just give to the court my, the copies that I tendered. And I'm gonna speak from my notes as to what it is about them and why it is that I believe it.
All right, well, hang on. Laura, can you have the substitute JA come down here and grab these and make some copies for me? Please, thank you. Because I have a tendency to write on things once I get them. I'll try not to do that until I get my copies, but. If you'll come around here, that way I can actually reach you.
You're welcome. And what, for the record, I have given to your honor, 1AS, which was the plea agreement that had been tendered at Mr. Sledge's plea. I've also tendered 444 Yankee, which is the document we were referring to, that is an exact duplicate of that. 451 Yankee, which was
Yeah, I mean, I know what they all are. So 451, 2, 3, 4, 5, and 6 should be, yeah, and 6, and then 460.
Yes, Your Honor.
Okay.
Your Honor, would the court permit me to take my seat so that I can read it?
Yes, you may.
Thank you. Your Honor, starting with Mr. Sledge's testimony, the court and I think everybody else is aware that as we referenced State's Exhibit 1AS or 444, my particular question to him after he started talking about his truth and his ability to tell his truth was using the guidelines if a acknowledgement that you signed.
Yeah, I remember. We don't have to like belabor the point.
Okay.
He picked out several and listed the ones that he said were false, and they were 3, 4, 5, 6, 7, 8, 9, and
Oh.
16.
Right. With the exception of about 4. Right. And then he said that he understood none of the sentencing.
At the time, yeah.
Acknowledgements at the time. So, Your Honor, under 24-6-607, OCGA 24-6-607, Your Honor. Impeachment by contradiction.
Well, that's not impeachment by contradiction.
Well,
That's who can impeach.
so as I'm reading, and I know that it's who can impeach, who may impeach.
It's a different one. 621 is impeachment by contradiction. A witness may be impeached by disproving the facts testified to by the witness.
Right. The reason that I referenced that only is because it was in the book that I'm reading from. There's a section that I'm looking at. So particularly a witness may be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, BEHLER versus Hanlon, HANLON, 199 FRD 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said. And we'll then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge, hey, number 3, number 8, these are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28th, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and what so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it, the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury, not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or take as statements by this witness anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed.
I'm gonna get copies made of all of these.
Yes, Your Honor.
All right, so. Just one. Oh, batteries, thank you. All right, I've got some batteries. If
Oh,
you
did they
think
go in
that
here?
might help with- I'll just put them up here.
It seems like your mic is out and you might need batteries. I don't know whether they take double A or triple A.
Double A over here.
All right, got a few of each.
I'm just gonna set those right there. All right, so I think that, there's the 444Y one, which is the signed plea acknowledgement. That's sort of a separate type than all of the rest of these correspondences back and forth. And are you at this point saying, just so I understand, that like as to 460Y, you don't even intend to redact it at all?
No.
All right, help me understand what you're saying.
As to 460Y, I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y, the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number one is okay, number two is okay. And I say that under, I would call it an adoptive admission, but he is
Well,
an
it's
agent.
an agent,
Right.
yeah.
So he is stating, his client is stating, number one is okay. And in order to know what number one is, the jury needs to see what number one was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says, that's okay. They should see whatever he wrote about 450, about number two.
Let me ask you something. I mean, is he really a party opponent anymore?
He
He
was.
But is he now? Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the,
You're saying, this is a statement by Mr. Sledge's agent, which it is,
Oh.
but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under
Okay,
that.
so-
I was just saying they are statements of Mr. Sledge.
Okay, all right, but under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So inasmuch as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently once he was on the stand to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and
Well, I know why you want it.
Corroborates the state's position is
That-
not a hearsay exception.
Right, I understand that. Yeah, so why is that not come in
Okay.
as a prior inconsistent
Your
statement?
Honor, first, I just have to address one thing.
Okay.
And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444 or we,
No, 444 is a different one, but yes, 451 through 6 and 460.
are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea
Okay.
acknowledgement.
So I'll address that.
Okay,
We all talked about this and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
yeah, let's
you
not
know,
get to that.
yeah, I won't get to that yet, but we've discussed this and now we're back to arguing about it again.
I don't actually know that we discussed 444Y 1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him and they said, this is what you're denying, factual acknowledgement. I'm using an example. 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with. So I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well,
That-
okay.
It's pretty clear law, I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation,
I
But-
know.
Right, but I don't believe that that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it,"
Okay.
and then, so
Well, the statements on the document say, every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
he did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter
It
if,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but
Why, do you propose to redact that at all?
No, and just as a
Well-
point of clarification, on the first day of direct examination, he specifically said that one was not true. He said that on the second day, he came back and said yes, but the first day he said no.
it's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number 1. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
It's-
the parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other, the 3 things that he said he admitted, 10, 11, and 12. 5, 10, 11, 12, 14, and 15. Provide context to the types of admissions that he was willing to make. It provides context.
All
I
right,
think.
well, didn't they watch a video
Not
of you
with-
reading out
Not
just the parts that he said were inconsistent?
Yes, just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence. The fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand, allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits his admission, it being corroborative doesn't get you over that line. So. Yes, sir. Yeah. Now, it may be that what you mean to say is that the entirety of the document needs to come in because that's the way they can understand it. Is that what you're saying?
Yes, I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the
What I
jury
asked-
in any way hear the factual acknowledgements that he still acknowledged?
I believe that the
You know
answer is
the
in
answer.
some form or fashion they did. For instance,
Hang on just a second, Ms. Love.
oh,
Mhm.
And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgments, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had an opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
and at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read?
That is, if I'm wrong, please correct me. I'm not trying to be wrong.
He's
That's according to my notes. There was nothing redacted. It went right from the acknowledgements, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play,
Respectfully, Mr. Steele is incorrect.
right?
We did.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah, I think that's the right date.
And what
Then
we,
maybe again to me at 9:54 a.m.
right. Would the court like to put it on the
Usually, moments like this, brothers and sisters, I hate to tell you, but usually Miss Love is right. So, you know, when it's kind of like this, it's kind of bet on Miss Love. Now, clearly, there are other times that she just out to lunch, it would appear. Allegedly. Possibly. Presumably. But when it's like this right here, yeah. But we'll find out. How you doing, brothers and sisters? We rolling. Thank you for being here. We appreciate you.
That's the right date.
and what
Then
we,
maybe again to me at 9:54 a.m.
right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
I know. Yes, Your Honor.
Okay. Okay, so
Yeah. Typically she's on it when it's like that, you know. That's just how it is. Moments like that, and it's in how she expresses it, in her demeanor, and you know, I mean, just studying her for as long as we have, you know, when she's right and she knows she's right, there's a few tells that we clearly see on this side. Now you also notice that during that moment, Brother Steele was having a side convo with the young brother Kokomo. You saw that happening, right? So we know that Brother Kokomo is their IT cat right over there, right? So, you know, he may have had a hunch that he might have read Miss Love's tell as well. You know, he's been watching her too, so he may also know how to read when she's, you know, like that. So he may be prepping for, okay, well, if it didn't get in like that, let's make sure, one, and then two, how do we need to move forward from a technology standpoint? Is there another clip that we need to get ready or double check on? So he's moving. He's still moving, regardless of if he misstepped on that first point. He knows there's a difference between the battle and the war. Holla if you hear me. Difference between the battle and the war, brothers and sisters.
oh yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. And yes, Your Honor.
Okay. Okay, so
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Shart's response about 444 and impeachment by contradiction and the amount of time spent on it.
all right, I'm not concerned with the amount of time spent on it.
Okay. Then not that, but-
So the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state to, the jury to understand what he was willing to admit to and what he wasn't later on. What's your argument as to why it should all come in?
So, Your Honor, reading from Morgan versus Morgan versus Covington, 648 F 3rd 172 Third Circuit is a 2011 case. The doctrine of, and this is quoted, this is cited from there. The doctrine of impeachment by contradiction serves as a means of policing a witness's obligation to speak the truth in response to proper questions and permits courts to admit extrinsic evidence that specific testimony is false, of course, because other evidence contradicts it. Other inadmissible evidence is admissible as rebuttal evidence where counsel opens the door to such evidence on direct or cross-examination. The doctrine of curative admissibility relates strongly to impeachment by contradiction. I won't get all into all of that, but when on cross-examination, Judge.
Appreciate it. All right, I'm going to give you your.
Would you get that? The doctrine of curative admissibility relates strongly to impeachment by
Hold on, brothers.
I won't get all into all of that, but
What is going on?
when on cross-examination, Judge.
Oh my goodness.
I'm going to give you your.
Brothers and sisters. Okay, first of all, fair is fair. Speedy was speedy. No joke. Speedy was speedy. then, okay. Glad she's okay. Glad she's safe. Shout out to Speedy. All right, Paige. You know, maybe if you would stand. Okay, since you're okay. So, okay. Is it too soon? But you're okay though, right? You said you're okay. So is it too soon? Okay, then I'm gonna say it like this. Maybe if you practice every day standing for the jury, you wouldn't have such difficulties being clumsy because you don't stand very often. My advice, hypothetically, stand for the jury more often. Make you a better you, Paige. And wouldn't that be something?
When on cross-examination, oh, Judge, oh, Judge.
Appreciate it.
When on cross-examination, oh, Judge, oh, Judge.
Appreciate it. All right, I'm gonna give you your.
And shout out to Miss Love with her sensibilities. Go on with your sensitive self, Miss Love. We see you. Okay, I got one more for you. Now this is for y'all, you know, folks that know about the church though. Again, glad she's okay. But for the brothers and sisters that know about the church though, you ain't hearing me. You ain't hearing me though. Cause when she threw up that right hand right there, what y'all know about? What y'all know about that? What y'all know about that? Ooh, because we know sisters be gigging in the church like that. When they hit that step, drop down, that hand go up. What you know about that? You don't know nothing about that. That's the Paige Heisman for you though. Glad you're okay, Paige. Again, stand up more for the jury. Help your legs, you know. Keep your leg strength up. Plus, you know, you don't want to, I mean, you can go catch some blood clots playing around like that, Paige. Longest running case in Georgia history. I'm looking out for you. Show the jury some respect. Stay away from blood clots. Rhodes. Looking out.
Lay strong into impeachment by contradiction. I won't get all into all of that, but when on cross-examination, oh, Judge, oh, Judge.
Appreciate it. All right, I'm gonna give you your
Would you get that back?
documents back.
Thank you. Miss Hilton's coming.
None of these are the, yeah, okay. Thank you. Sorry to interrupt. Good.
Yes, Your Honor. So we're not just talking about, if we were only talking about inconsistent.
Yeah. I got something else to say. Skip y'all. You know I got number love for you. Skip y'all. I'm gonna make you mad one way or another. But them sisters Love and Hilton though, they be wearing them 9-inch heels and they ain't wobbling a bit. What? Them sisters standing on them hills 9 hours a day. What? They go and hoop in them hills. Please. Them sisters? Okay, they falling down. Okay. Please. Give them the rock and see what happens. They be crossing you over them hills, guaranteed. You saw how Sister Simone just strutted to get that. She was representing like, please. You can't even walk straight. Let me show you how it's done. Let me show you what true leg strength is about. He'll say, look, I'm gonna show you how to do this thing. Okay, just watch. Pay attention. Pay attention. This is how you walk. You ain't got to worry about nothing. I can go left, right, up, down. 20-inch heels in your face. What?
Sorry to interrupt.
Pass me the rock.
Yes, Your Honor.
Look at her.
So we're not just talking about.
Ain't no stumbling, baby.
Inconsistent.
Look at stepping on roaches. Even killing roaches on the way in. Here come a delivery. She doing rodent patrol and everything in them heels. Look at that
So
watch.
we're not just talking about.
Like,
if we
hey,
want
what is that?
inconsistent,
Oh, dead now.
Statements, then that would limit us to a portion of it. But here on cross-examination, the entirety of the cross-examination was intended to present to the jury the impression that the statement itself was not knowingly or willingly or voluntarily agreed to. And in fact, even though the court sustained the objection to the question, I believe Mr. Sharp said it, or I'm sorry, forgive me, Mr. Sharp, Mr. Weinstein said it when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, when the effort is, and the witness has allowed it to happen, that an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. The validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't valid. And so in as much as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context. We'd ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, there's no contradiction. He said that the state presented me a form that they wrote on their letterhead and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. So there's no contradiction. The document doesn't contradict anything he testified to. Now, there needs to be a hearsay exception, and the reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video, and we've already heard it. And if they're arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video with all of that being read, the jury's watched it, and that was covered. So at this point, that form for any hearsay exception that it would fall under, that's already been covered by the video.
All right, I'm gonna rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of a prior inconsistent statement. And we'll deal later with whether they actually go out as continuing witness or not.
And for the record, which ones are those?
So I think that would be, if everybody has it in front of them, my understanding is he disavowed 3, or at least portions thereof, 3, 4, 5, 6, these are all under 4, under, factual acknowledgements, 7, 8, 9, and 16. And then every bit of Section 5, the sentencing acknowledgements. He said he didn't understand any of them, even though he initialed saying, I understand fully each of them. as well as the paragraph underneath that.
He also acknowledged on day one of my direct, number one, I wrote it, though he changed that.
Well, if you changed it, then it was no longer inconsistent. I mean, I didn't, when you were like, all right, here it is in front of you, tell me which ones there you have any type of problem with. He did not say number one. So.
He,
Done, I mean, I made my ruling. All right, so that's that one. That is, and I don't know whether you're gonna tender 444Y. That would make more sense. You've established that it's the same as 1AS.
I did.
Okay.
When,
I'm listening. Yes?
I'm going over, just one moment, Your Honor.
Okay.
Yes, Your Honor, that is, we understand the court's ruling with respect to 444Y.
All right. And I don't think it would come in as, whatever it's called, the rule of completeness, because that would be if one party's introducing it, the other party has the right to do more, and this is all one party over here trying to get it all in, so that doesn't apply. All right, I think now we can move on to the rest of them, which are all sort of, I need a bigger bench. The same thing. Well, I guess what's in 460 is not contained in any of 451 through 456, is that correct?
Well, 460 is Mr. Wright's email to us.
Back, okay.
Right, and so 460, and by 460, I do mean the last four
Right,
pages.
the part where he says, let's not do these ones, or here are the issues with these ones. So do you actually want or need the rest of them in?
Judge, because, so
And if
the answer
so-
is yes, and I will.
Okay, under what basis?
Okay.
Under what evidentiary rule?
Yes. So as to number one, because Mr. Sledge, on the second day, he agreed and gave testimony about examples of number one. It's not so much that it's an inconsistent statement as it relates to number one, but when Mr. Sledge on cross-examination asserted that he did not have the ability to change things, that we didn't change things for him, showing the way that the recommended changes were presented to the state. What is not said is as important, in our opinion, as what is said.
All right,
If
are we
they-
talking right now, I'm sorry, about just that portion of 460 that's Mr. Wright's 8:43 PM email?
I should have been clear. Yes,
Okay.
and the second part of that is just a duplicate where I asked that
Right.
copies be made. So we are only talking about Mr. Wright's December 27, 2022, 8:43 PM response to the state. Subject line is Sledge agreement updated. And with Mr. Wright on the stand, I clarified what exhibit came in before that he was responding to, which was 452.
Okay.
And then what exhibit came after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as, number one, he's saying, okay, there's no caveat, there's no, oh, we need to dig. Okay. So number two, obviously, Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL blank.
Right.
So
What-
he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is,
Yeah.
we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang
What makes it a gang is a
violation
crime.
to commit
Okay,
crimes in
so
furtherance of it.
And that's why.
That is good
one,
to
two,
just refresh, brothers and sisters. Because again,
multiple
to hear
times.
that,
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal. Case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well,
and that's a big misconception, so not really something that should be taken lightly. Because common understanding is that, if they're in a gang, then it's illegal. And that's not actually what the law states, per those that are legal eagles. And what Paige just said, you have to prove more than that, right? Just because cats together, they could be a bowling team. Cats hanging together does not necessitate illegality. No, that's not how that flows. And so this is where the state has the challenge to bring forth so-called evidence of doing things in support of doing illegal things, right? To benefit, to promote, to defend, to bolster that entity. And that's where you go from there and expand with this RICO and say, okay, and that's what we were talking about earlier. Well, this other dude over there did that. And even Ms. Love, she's definitely aware, because she stated it earlier today. She's like, well, what the defense wants to continue to do is say, yeah, that guy over there may have done that, but it had nothing to do with this. It had nothing to do with the entity. It had nothing to do with this organization, allegedly, you see? So it's separating it, because you have dudes who actually, like homeboy Lil Rod, who's sitting over there, right? Say, well, he's actually been convicted. He's actually guilty of the M word. Now, as Brother Sharp said, it's under appeal. So let's just say allegedly, right? Whatever. But that's what was said earlier, that he's been found guilty and it's under appeal. All right, it is what it is. The point being is that, let's say that stands, okay? Because there is certain precedent which says that even if it's under appeal, it does not stop it from coming in, by the way. But let's just say it stands. Let's call it true, okay? Fiat. So if that's the case, then you want to at least separate that, though. You want to say, well, he did that junk all on his own. That, just like they're trying to do with Brother Sledge, Mounk Tounk, say, well, that was a situation that was going on with Trevius Smith and Shell Kettle. It was a love triangle. It was between the three of them. It ain't got nothing to do with the organization and nothing. If Professor Woody did something, he just did it on his own. He was just being a knucklehead. So at least if you can't get away from what the incident was, then you at least want to make it just be on that person. Because once the state is able to show that the incident did occur and that it somehow was profiting or benefiting, and that's where those list of so-called factual assertions, etc., that's where they come in, because that's why it's written the way it was. And that's why he got to get out of, Mounk Tounk gets to get out of jail free, get out of prison free, 30, 35 years, because point by point, him acknowledging these so-called facts, factual acknowledgments, it builds that case for the state. It shows the connections. And that's why she's asking, or she asked, says what? Hey, when you did that, how did that benefit the organization? See how loaded that question is when you understand the context of how the law works? Say, well, how did that help the group? And then what did he say? Oh, well, it helped because it showed people not to mess with us. Show people that we ain't no punks, man. You can't be just messing with us. That's how, oh, really? Remember, we were like, oh, man, no, he didn't. Because that connects dots. See, now, well, a second ago, you said it was just because of this. Well, you mean that drive-by? Why we do that? Oh, because you can't be messing with us. Now, there is a couple of slippery things, though, inside of that. And what's that? Because remember, he's also saying, but that was a different organization with the same name. Yeah, that was YSL, but it wasn't the record label. And y'all trying to say that it was the other thing. So at that point, then it becomes more complex for the jury, right? Because now he's saying, well, or allegedly or possibly saying, yeah, there is a gang, but it ain't that one. It's a different one. It's the one we were in. And that one is not the same one with Lil Jeff. He's in the record label. They just got the same name. So it gets funky at that point. But this is also why the state is trying to pinpoint that he understood enough so who in heck they were talking about, why they're talking about what they're talking about, so they can build the connection. And then the power of that RICO comes down like an anvil, right? If she can show the connection and the jury buys the connection, bad, 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 baby. Bad, bad, bad. And they can fumble their way there, right? They can have a bunch of lousy witnesses. They can be unprepared. The state can show up late. The state can leave early. The state can do all kind of, weird, foolish stuff. I mean, just stink up the place. But at the end of the day, months and months and months from now, if they can still go to a big board and say, okay, see how this dot connects to that dot. And if the jury is like, well, yeah, that dot does connect with that dot. And that guy did do that. And he did say he did that for that group. It's all bad at that point. It's all bad. So what I'm saying is they can fumble their way there. Is that justice? That's the power of that RICO. Oh, and let's not forget, they don't just have RICO, they have people with plea deals. They have people who have agreed to connect the dots for them to get out of jail, right? To go home, to bypass 30 years in prison. They've got people who said, yes, I will come in and tell you what you need. I'm on video saying I'm making the connections on video. I'm making the connections when you tap my phone. Allegedly. It's bad news, baby. It's bad news. Whoa. But let's go back to the core. So yeah, just being in a so-called gang is not illegal based on the law. That's our understanding. But it's what you do when you start to do things illegally for the benefit of that entity, of that group. That's when they can get you. Rhodes. Let us know what you think about that.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang
What makes it a gang is the
violation
crime.
to commit crimes in furtherance of.
And that's why number one says.
Right, and so, I mean, number one is whatever number one is, but, you know, that number two says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm going to defer whatever the court's ruling is,
Mhm.
but it's that he's offering additional information. He's
I think
comfortable enough to say,
I think that is okay, I think it was about 3 years beforehand, so it must have been about 2012.
okay.
Okay, so,
Nu-
3,
Number 3.
didn't we read that into the record?
We did. We read the response Mr. Wright gave,
Okay,
and I
We
believe
did
we
read that.
read,
We did read it into the record.
if I
Your
make
Honor.
it, I
right.
believe we read as well the portion of 452, that was number 3, and then the final. I think we read 3 number 3s into the record, just so that the court is hearing what I believe is the full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
We read at least the final version of number 3.
We
many,
did.
Many times.
Okay.
So number 4, back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number
remind-
4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4, told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination, now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor, ma'am.
Number
Yeah.
5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they
ex-
were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
it
true.
was true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying.
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That needs to be kept out under 403 if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really the only thing from this that you wanted in?
When you say this, you mean
From this being this part, the 8:43 PM email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even, the language of what he says, I didn't even need to have that in. I mean, I understand why that would be considered, and I understand the court's position there. why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. And we could take out all of number 4 under Mr. Wright's email and just say no. I don't, just, he denied it.
Well, we can't make it say something. it
No,
doesn't
not
say.
put the word no.
Not that we do
He
a no.
said, Mr. Wright said on the stand
Okay.
that is something that we did not agree to and we took out.
And that's exactly the point. Mr.
Exactly.
Wright said all
All right.
the stuff on the.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, provides, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration, that there was an objection to it being called a prior iteration. And I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see any prior versions? My recollection is that he denied.
I don't remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer. That
And
was his-
Mr. Wright clearly testified that he took a version to speak to Mr. Sledge the night before.
And you know, I'll look back at.
All right, well, subject to that actually being some kind of so that would be what, impeachment by contradiction?
Yes, it would.
Okay, well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Okay.
The state, under the state's theory, well, I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all. And then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
I understand. You can get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you, and I will look for that.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which I, in my mind, in the recesses of it, believe that it may address.
Oh, Miss Love. Go, Sister Love. Go, Sister Love. Miss Love said, so check, way back in the recesses, dropping the poetry for you. Go on, Love. Hey, I see you, girl. I'm listening. Go check in the recesses of your mind.
In my mind, the recesses of it, believe that.
Yeah.
With certainty, but I'm just going to ask if there there's also a case which I, in my mind, the recesses of it, believe that it may address specifically like
Okay, well.
iterations.
Sure.
Okay, thanks.
And shout out to Brother Sharp. He's been coming with some good intensity during these objections lately. He's not standing for it. He's like, hey, we're wasting time, doesn't make sense. The state could just, man, we ain't had nothing to do with this. They could just do this, they could just do that. Man, this is bogus. Skip them. Don't let the state get away with this, Paige. Yeah, I'm not gonna let it in. All right then, I thought you wouldn't. Cause I'm tired of just playing passive with y'all. I can't get nothing done like that. I need to bring some funk. Shake you up a little bit, Paige. Talk to him, Sharp. Let him know what time it is. Yeah, get something done round here.
Even if Mr. Sledge did say there were never any other versions, and which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Your Honor, with respect to the 403 concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially the argument is that this isn't a statement that Mr. Sledge made. Showing that Mr. Sledge, showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
That's the ultimate one that he signed. But showing, yes, it is.
I know.
Showing that he was untruthful and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and help them to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling, revive the ruling that the court made.
Denied. Let's move on. All right, what were y'all tasked with over the lunch period?
Your Honor, we reviewed the proposed segments of those videos that showed Mr. Beebe and Mr. Eppinger referring to and they weren't referring to it, but it's clearly involving the armed robbery that they're charged with that's listed as an overt act. I can say on behalf of myself and Mr. Steele, we have objections. I think Mr. Steele was going to articulate them to those segments.
Okay, I think it would probably help for me to be able to see what those are, but before we do that, 463Y, were you intending to tender that at all? I don't know if that was one that you had included that we said we'll circle back or not. That was the one that was just his sentence that showed that he got the sentence on the second count too.
No, that was just to
okay.
refresh his
All right,
memory.
thank you. All right, can you cue up the portions of that video, please? Hmm. Together that, just the portions of that guilty plea. So if we're going to be just showing portions of various videos and things, if y'all could do that for those as well, that moved things along much more quickly.
Thank you, Judge. We will, after we,
Great.
work it out.
Decide. Okay. Thank you.
The first portion of this video, it ends in 2624. In the video, this is Durante BB, and it'll be Christian Eppinger. This is after the armed robbery that both are alleged to have committed. Mr. Beebe has recently or did plead to the charges in this indictment regarding this armed robbery.
All right, so I'm sorry, timing wise, this is shortly after the robbery or shortly after?
Shortly after the robbery.
Okay.
And we're going to begin the first portion at 1:12. And it's about 3 seconds, Your Honor, from 1:12 to 1:15.
What's going on now? What's up, Slam?
And Your Honor, as you see, or if you see there, when Christian Aperture gets onto the call, he throws up what we have alleged is the YSL sign, and then Durante do it back towards him.
Okay.
The next portion, Your Honor, is 2 minutes and 45 seconds to 2 minutes and 52 seconds.
Anybody, I'm out there. All right, Slap me.
Can you get rid of that box by chance?
Yes.
I don't know why that does that, but.
And so, Your Honor, if I need to play back, I will, but when they're ending the call, they both say slat, which is a terminology that we are alleging that YSL members
Right.
use. And then the last portion is 356, 408.
But they hit them up. Really, yo, my artist, man. They give me, I done built me a business up.
And it ends there. Just a few things. The clothing that he is wearing, Your Honor, I believe this is OTS on the slime clothing that he is wearing. This is also his public page. And so immediately after this call, he then points a gun at and towards the camera. Again, going towards the state's theory that members of YSL operate with violence and using guns to show their threat, their notoriety, and given everything that has happened in the video, those relevant portions. Those are, for this video, the 3 portions we see.
Ms. Hilton, excuse me.
Can you not hear?
I didn't quite follow the first thing she said. Something about what was on the clothing.
We believe that this is clothing that we've seen on other YSL members. It's either OTS or on the slime clothing. We've seen, and I think we have a few other posts, Your Honor, with them wearing similar type of clothing, but it has either YSL or related terminology on the clothing.
All right, and on what piece of clothing is that?
On his, I believe, the headpiece as well as the shorts,
All
Your
right,
Honor.
can you show me that last portion again?
Yes, Your Honor. And I started a little.
So, the headpiece and the shorts.
They ain't got no involvement, but they hit them up. Really, yo, my artist, man. They give me, I done built me a business up.
And what does he say?
Built me a business up.
I heard that part. What does he say before then? Is this just to show the clothing?
No, the clothing and the pointing of the gun.
And pointing at the gun and saying,
They hit them up. Really, yo, my artist, man. They give me, I done built me a business up.
I think he's rapping a lyric to a song, but he says he hits them up, and I'll have to go back and look at the portion of the language.
Your Honor, procedurally, are you wanting us to argue these one at a time
I
or?
think, yeah, that'll be this set, not like, well, not necessarily one portion at a time, but like this will be, I'll hear the argument as to this. So I guess there's the beginning where they're throwing signs, the end where they're signing off with the language, and then the middle, the end of their call, and then the end of his post where he is wearing particular clothing, pointing a gun and saying something indiscernible other than that he's going to build a business up, but maybe you can let me know what he's saying. But if what he's saying doesn't matter, then.
I have,
Okay. All right.
I have reason to believe that he's singing a popular
Okay.
line from a song that
All right.
does not involve anyone in this room.
Okay. So is this line of, what's the line of clothing? Is it like a line of clothing you can buy in stores?
I don't know if you can buy it in stores. We believe that there's one member of YSL, Miles Farley, who is purportedly a clothing designer. He creates
Okay.
some of the
So-
clothing.
That is
Okay.
not,
I don't know if this is that,
that's
but
not his clothing line.
oh, well, but the clothing says, and I have another picture, because I believe this is from all the same line.
Okay, but I mean, if this is something he's wearing and you want it in to show that he is a gang member.
And the clothing says, and I want to back up, we believe it says slat on the clothing, on the shorts. And I'm looking at another act that we have at 143 with him and Christian Eppinger, and Christian Eppinger wearing a jacket similar to the pants and the hat set that he's wearing in this particular video.
And when is this from?
This video is around October of after October 10th of 2021. The armed robbery takes place in October of 2021.
All right, and tell me why y'all are offering this.
Your Honor, so with the first two portions is to show that both Mr. Eppinger and Mr. BB, again, right after the robbery, are in communication with each other, showing their association with YSL by one, using the gang symbols, and two, using terminology in which members of YSL uses. And then the last portion of the video, which is when he places the gun inside of the video, Your Honor. Again, this is a public posting of Mr. BB. And it shows, again, that members of YSL uses this gun for no reason, comes into this video at the end. There's nothing, I don't know what the purpose of actually flashing a gun is, but to show that he, as a member of YSL, has handguns, uses handguns, especially coming after an armed robbery, which we allege.
All right,
he
and the
uses-
armed robbery was what, like October 12th or something
October
like
12th of
that? And then when
2021.
is this video posted?
I just need to pull up the Instagram, Your Honor, of when this exactly video was posted.
And can I ask the state another question while we're looking into that? It's being, and I'm sincerely asking, it's being stated that this is a public posting. And I'm wondering was it a public posting or was this something retrieved off of his cell phone? Because those are two different things.
It was not retrieved off of his cell phone. We got an Instagram return for Mr. BB.
So yes.
So
these
was
are
this on his
public-
Instagram page? Was this a story that disappeared after 10 seconds? I'd need a little bit more context about what exactly this video is and where it came from and how it was presented to the public.
And again, brothers and sisters, that's part of having big time attorneys, man. You know, just because the state says, oh, well, this something should come in, or oh, we got something this way. Nah, you got the big time attorneys that can check it. Take as much time as I need to be like, oh, no. We're not gonna just take your word for it. You know, we're gonna call you on this stuff, keep you honest. Or at least somewhat. Good job, Sharp.
I'd need a little bit more context about what exactly this video is and where it came from and how it was presented to the public.
It came from his Instagram return. His page, we do not believe, was a private page. And the Instagram video was of him. It's a Instagram call that he makes with Eppinger, so it has to be public because Eppinger knew to log into the call when that's how he gets onto the call.
So is it public between the two of them? Forgive me, I'm not.
No, I believe it's
super
public to
familiar.
Instagram because
To his private page? Because you said it was a public post on a public page, but then you said it was from his private page.
no, it's his personal page,
Oh,
but
okay.
a public.
You don't mean it's private, you just
No,
mean it was his page.
personal page.
Your
Okay,
Honor,
but it's a
people-
public page.
People that are younger than me that are helping me here are telling me that this is not something, like if I wanted to check out what Mr. Beebe was doing on Instagram, it's not something that I could find publicly. This was a call.
If you followed it, like if, I know a lot of people have lots and lots and lots of followers, like thousands and millions. Would any follower be able to see this? I'm just trusting the youth in the room now to. I can Google it. All right, let's assume for now that this.
Well, there's a couple interesting things, brothers and sisters, we might talk about later. But you see how she just said she can Google it? Well, this is something we want to talk about, brothers and sisters. Put a pin in that. We'll get back to that maybe later.
I can Google it.
You know, essentially, let me go ahead and hit it just a little bit. Remember earlier when she reconfirmed that the brothers can't have technology, no laptops? What do you think about that? See, the way the world is now, AI and everything else. Hey man, if I'm on trial for my freedom, I could be spending 30, 40 years. Forget it. You know, that's my life. And the way the world is, and everybody in the room can have technology, but I can't. Hold on, wait. My attorney works for me. Talk Rhodes. That's my money. This is my life. My attorney can have access to a computer, but I can't. Wait. I'm gonna tell you again. My attorney works for me. So unless, remember, I'm supposedly innocent until proven guilty. I say I'm supposedly innocent until proven guilty. So was my crime? Did I do my crime through technology? I mean, did I do some type of cyber something or something like that? I mean, what is that what I'm on trial for? Because I understand, I can't touch a computer because maybe I'll hack into the, something. I'm blah, 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 hypothetically, presumably, whatever. Okay. But that's not necessarily what the deal is. What if I hear a term and I don't have any legal training. I want to understand what that term means. I might just have a question. Even while my attorney is speaking, I don't want to interrupt my attorney because he's in his flow or she's in a flow, but they just dropped a term and I'm like, yo, that gave me an idea. I can Google right quick or better. I can use AI right quick. And then when I have a consult with my attorney, I can talk on a different level because I understood something in my head, but I don't know lingo. Or maybe I heard something and I need to frame it so I can even ask a more effective question. All of this helps me what? Defend myself, right? So the way the world is, and there are laptops everywhere and cell phones, all okay. But I can't have access to something. I don't care if you even, somehow limit it, right? Where you can't make any calls with the computer. shut down access to certain features. There's stuff you can do, just like in a classroom, there's certain things that you can block out. You dig? But I'm saying research. When you call out a case, maybe I want to look up the case just like you doing it. I want to find it. So even the judge talking about she going to use Google to find out something. Whoa. You get to go home and sleep in your bed tonight, Paige. Why I can't have a chance to sleep in my bed? I heard 20 terms today that I didn't know what they meant. But you said I can't use a laptop, so I can't look up these terms. How is that justice? And again, what if I can't afford a Max Sharp, a Brian Steele, Keith Adams, etc.? What if I can't afford these top dudes? I gotta be working with my attorney for real. Cause they just struggling. They might be new to the game. Hey, we gotta figure this out together. And we going up against RICO? Oh, please. We need everything we can possibly get in our favor. So I'm sitting here every day for 8-10 hours and I can't look up nothing. I can't help myself. I can't help my attorney. I can't help my own freedom, but everybody else can do it. The people against me, they can do it. How is that justice, brothers and sisters? You don't want laptops. Okay, you don't want me playing games? Is that the point? You think I'm gonna be playing Miss Pac-Man on this thing? I'm trying to get out. I'm trying to see my babies. I'm trying to learn what's going on. I'm trying to keep up with what's happening so I can help the defense of myself, if you don't mind, Paige. So again, you gotta have a better legitimate reason for why I can't have a laptop. I can't have access to information in 2024. Why I can't have access to AI. I can't help myself. Shucks. What's someone do? Get it by some type of pigeon or something? How am I supposed to get these messages? I need information. Huh? Can I go to the law library on break? What's the deal? What's supposed to happen here? But you can Google something that you don't know about. Man, this is my freedom. Exactly. So here it is. I'm saying in today's times, look, it's my money. I'm paying for the attorney. It's my freedom on the line. And with the way technology is, unless you have a bona fide reason to keep technology from me, I'm not even in handcuffs right now. I'm supposedly innocent until proven guilty. I can type, not in cuffs. You got guards all over the room. There are sites you can block out so I can't get to if that's what you're worried about. I want to be able to work on the case. I want to be able to learn what's happening to me. I want to be able to follow along effectively. And I can't interrupt my attorney every 5 seconds because he's supposed to be listening to you, finding the little junk you trying to do to me. So he or she can't be stopping to explain everything to me. That's going to be hurting the case because then he can't listen effectively or as effectively as he could if he didn't have to walk me through everything. Ain't got to do that. When I'm sitting here for all these hours every day, oh, you must not want me to learn. You must not want me to spend all this time developing my mind so I can figure out what's going on, so I can help myself get some justice around here. What you got against that? You chain the Bible to the pulpit? Yeah, you're doing something. You're putting me up on a tree because you found out I could read? What's going on here? Why is me educating myself offending you? Why you got a problem with that? Rhodes. Yeah, so you Google what you need to Google. But don't stop me from Googling what I need to Google. It's my life, my freedom.
I can Google it. All right, let's assume for now that it's a public page and we can circle back
My
on that.
understanding is once a call, and this is my confusion why I'm asking the state. Okay, I'm using call, but
Once
it's not
the-
technically a call. Okay, but once the interaction is done, it is not saved. This is what my understanding is. It's not saved on his page. So I would not be able to say, hey, you know, for instance, if I said,
Could you watch it while it's going on if it's being posted to the page?
if you were, I think it depends if you were invited.
If you're a follower, I mean,
Yes, so.
whomever.
With Instagram, if they are on a Instagram story, oftentimes,
Mhm.
the other person watching your story could get onto the call if you accept it.
All right. Can they watch it regardless?
Yes, can they, who's the next?
I don't know. Somebody other than the two people communicating
Yes, other people can watch.
can watch it.
Are you saying can watch it if they're given permission to watch it, or are you saying they can just watch it? Because our
If they're
understanding,
followers or if it's a public post.
They can watch, I can log on, if I was friends with not a friend, if he has a public page and he's in his Instagram story, he's talking to someone, I can log in and watch.
And then there's clearly something he does even after the communication is over that he's showing in the post.
Right, and he can, and then the other person, Mr. Evanger, can come out of the call, and he can continue.
All right, and does it disappear or does it stay up
I
until you
believe
take it down?
disappears. I believe it disappears.
Okay, so it's up for 24 hours. And do we know whether this is an Instagram story?
I'm going to confirm, I believe.
Okay, well, we'll assume for now that it's a public Instagram story that's up for 24 hours.
And I'll add one other thing, and I can't say this with certainty. On one of these calls, or whatever they're called, one of these interactions between him and Eppinger, it was determined that no one was in the room. So I don't think that there's the room meaning watching. So
The virtual
I
room.
don't believe that.
Well, I'm not sure that matters
Oh,
if you're
well.
posting it to be consumed publicly, if there is somebody watching.
Okay, well, I think you can tell if there's people watching or not, and I think it was this call, but I don't want to swear to it.
All
But I have no evidence that anyone was actually watching, other
Okay.
than him and Eppinger.
So do you know when the post was made? Have y'all been able?
I misspoke, Your Honor, the posting was 2 days before the so on October 10th is when the posting, according to the Instagram video, was
Okay.
taken.
All right, but close in time.
So it was close, so it was 2 days before showing
All right,
these two individuals.
okay. I think that the first two portions are relevant and not excludable under 403. The third one, unless you can get me a whole lot more to explain why that clothing makes any difference at all. The fact that he's holding a gun when nobody can, when all he's doing is singing, doesn't show anything.
You're right. He is representing, we believe, with the clothing on YSL prior to an armed robbery that he commits with.
Okay, I understand you believe that, but until you can get me some basis to believe that,
To believe that the clothing is.
that the
Why-
clothing, yes, it makes
Yes.
any difference whatsoever.
So, Your Honor,
So.
with respect to the case law that has come out after Rodriguez and all in the furtherance of a gang.
Uh-huh.
So some of the things that courts have named as evidence of furtherance of it being done in furtherance of the gang
Mhm.
is whether or not the person is wearing items of clothing, articles of clothing that have or bear the gang name, if they say the name, if they do things that represent the gang in close proximity to the time of the crime.
I understand that.
And with the fact that he is pointing the gun at the camera and saying whatever he's saying, we draw the analogy that in pointing that gun at the camera, if, as Ms. Hilton is looking, we find sufficient to the court's satisfaction that he is wearing YSL clothing, in the same sense, he's representing YSL as he's pointing that gun at the camera, making the statements, whatever they are, singing or otherwise. And in doing so, he is making a public assertion about YSL's willingness to perform violence
Sure.
or to, you know.
All right,
use
y'all
it.
get back to me on the clothing.
I'm ready for the
Okay.
clothing.
I
So
think-
I'm going to show a portion of the video.
Your Honor, I think I'm probably stating the obvious, but that's not when the armed robbery happened. So,
But yeah, it sounds like it was 2 days before.
yeah, so I don't know about what Ms. Love just said, this has nothing to do with showing that the armed robbery was somehow gang related. Even if he's wearing that clothing, but Your Honor, regarding the clothing, again, I agree with Your Honor about the ruling and we'll look at the clothing, but the gun, I don't, like, the thing about clothing is we can get a screenshot and see what someone's wearing. I don't know why we have him rapping and pointing a gun because that is just
What
a
lots of
man-
people unfortunately do these days.
right.
Your Honor.
Yes.
And further, what clothing is this? Because Miss Hilton, first she said she thought it was one clothing, then it might have been somebody else's clothing. So can you please tell us what clothing line is this?
I can't tell you the clothing line. I can just tell you that the clothing has flat on it. And if we look at his shorts, and this is at timestamp 3:43, I'm using this timestamp, and then I also now want to show the court Act 143 with someone wearing the same similar clothing, and where it's clearly that it says flats on the clothing, which is terminology used by YSL. So
Okay, you're showing us where it says this on this clothing.
So on this clothing with the black base, the blue lettering says slats. And then there's also some red items, but we know that the blue lettering says slat. And I know this, or we believe it is this because just need to pull up.
Do you have him wearing other gang paraphernalia at other times?
That's what I'm
All
pulling up
right,
now.
then that's gonna be sufficient.
So Act 143, Your Honor, which is, we believe on September 29th, 2021, so about 2 weeks before the
Mhm.
video, Mr. Eppinger, who he's in the video with, is wearing the similar clothing, the slats. He just has the jacket version on.
Okay,
And then BB is wearing the OTS, which says only the slimes. I don't know who created it, but it's slime clothing or slat or YSL affiliated clothing, Your Honor.
and who is that? Is that,
So that's the same. So the person in the jumpsuit is Mr. Durante Beebe. This is the person who had the gun in the video.
Uh-huh.
Next to him is Mr. Eppinger, who was the person who joined.
okay,
the
so you
video.
have both of them a couple of weeks before wearing what y'all allege to be gang clothing.
Yes, Your Honor.
All right, that's enough. You can have those two portions that are the beginning and the end of his call, and we're not gonna do the third portion.
Okay, thank you, Your Honor.
Yes.
I want to, if you rule definitively, I want to just put my objection on the record. These are out-of-court statements. Mr. Beebe and Mr. Eppinger are not here.
Mm-hmm.
So it cannot be, the way I understand the law, admission by a party opponent because they're not on trial with us.
Right.
And therefore, it has to come under some sort of co-conspirator hearsay exception. And I don't know how this furthers a conspiracy to say, and I believe these are quotes, what's going on in the first 112 to 115, Your Honor, and then what's up, slat. I don't know how that furthers the conspiracy, so I'm objecting to the verbal. In addition, I asked the court, there are a tremendous amount. There was a contest on the internet who can say slat with a song so many times. I tried to put that in evidence, and Your Honorable Court sustained the state's objection and said, who cares? It's a popular thing that is being said now, and who cares that people are on the internet saying that? The state just said that slat is important because that's what YSL members use. I want to show that everybody uses it. And slat was a popular term before 2012 when this supposed gang formed. You will learn if you let it
Did
in.
somebody already establish that? I know
tried
you
to.
established it with regard to like some of those other sayings.
Yes, Mr. Trentavious Stevens stated that when he was younger, it was made popular by a rapper, an artist named
Right.
Lil Wayne.
Okay.
So I was stopped from doing it. So I'm objecting. I understand. I'm not trying to belabor this, but I'm objecting to all the verbal statements. And then I just think it's nothing here to me furthers the conspiracy. And
All
that's
right,
the only
well,
way to do it.
Thank you. All right, so that's that issue. Oops.
The next video.
Keep in mind, brothers and sisters, Brother Still was not trying to get her to change her mind. He wanted to get it on the record. Planning for the future, baby. That's what we do around here.
3396. And I'm going to find the date, Your Honor. This is after the robbery. And we'll play from 10 seconds to 2 minutes and 52 seconds.
Do you know how far after the robbery?
That's the date we're looking up now. Yes, sir. This is on 10/13/2021, so one day after.
One
the
day
robbery.
after, okay.
All in the club throwing gun signs. All in the club throwing gun sign. Got all the fuck going on, man. Shit, YSL.
Few things, although he's in the bed saying he's in the club throwing gang signs, he threw up the YSL sign in this video. He threw up, we believe to be the little B blood sign in the video. More importantly, I freeze frame on the chain. This is the chain that was stolen from the victim 2 days prior to, or a day, excuse me, prior to the this video being posted. He's also wearing, you can see his headpiece or the hat or the mask that he has on his head is also another.
Ah, man. Say it ain't so. Bro, this is him over here having a nice little snacky snack. Well, I guess it's a mealy meal. And then all of a sudden I hear that nonsense. Now, first of all, I'm watching thinking, once again, these cats showing stuff they shouldn't show, okay, so that's unfortunately not new. All right, so another case of that on social media, right? Then I heard what Sister Simone just said. Did you hear her? Yeah, you heard her. Okay. So she says, alleges, that this is the same chain that was stolen from the victim a couple days before, before the incident. You feel me? Brothers and sisters. Golly, man. I'm over here fighting for justice, man, but hey, we got to do better. You hear me? Don't even get yourself in this spot. I'm calling it fair, trying to fight for justice, but don't be no doggone knucklehead. For real, for real. Come on now. What are you doing? Allegedly. What are you doing though? Golly. And then I'm gonna post it. You gonna do what? First of all, this is beyond, right? Like, okay, young man, don't do the deed, right? But we're way beyond that. Allegedly. We're beyond, hey man, it's not right to do that. But these knuckleheads, allegedly, are not only doing things allegedly, but then you're posting on social media the deed, evidence of such, allegedly. What is wrong with you, man? Yo, I know your phone work, because if you ain't got no TV, no disrespect, everybody ain't watching TV, but I know your phone work. You probably got 2-3 of them, allegedly. So I know they work. So you didn't watch the videos. You didn't watch the movies. You got no excuse. You know not to do what you're doing. Man, come on. How do I give you a pass for doing stuff that's just wrong on top of wrong and then incriminating yourself for a like or two? Maybe you get thousands, who knows? Okay, 1,000 likes. Save your 1,000 likes. You gonna hit me with 20 years? Yo, 20 years for 1,000 likes? I don't care. 10,000 likes, 1 million likes. I gotta do 20 years? No. Keep your likes. I like my freedom. Whoa, Jack. What is this stuff? why am I posting evidence of, oh, so that somebody else can see and see I ain't no chump. If you want it, you can get it too. Okay. So then they come and let's say they miss, but now you got to go get them, right? Okay. And then what you gonna do? Post evidence that you got them too? Okay. So the next teammate comes back at you, allegedly, possibly, presumably, supposedly. So we just document. So we making documentaries. That's what we doing. So we making evidence and documentaries. Who do you work for? Because it looks like before you get paid, a lot of these cats end up in prison or the morgue. So who pays you? How are you getting paid for this? I mean, if you're making free documentaries, yo, what's up with that? Really? I mean, you developing content that you're not going to be around to benefit from? Dog, you just heard Paige Speedy Whitaker tell these brothers again today, they can't even be on the laptop. So you won't even be able to watch your own video. Ooh, Rhodes. Ooh, Rhodes. Lock your butt up and you can't even watch the video that got you locked up. You got to wait for them to play it in court. Like, dang, I wish I could watch my video. Oh, they going to show it to you. You be able to see it, but not when you want to see it. No, we going to show it to you when we want to show it to you. Wow. And guess what? The playing of the video will make sure that you get more time. Wow. Yo, I mean, okay. I'm working on trying to find a pass or something. I'm trying to find, and I can't see where. Hold on. I'm working with you for a second. I ain't going all the way with you. You still doing some dumb stuff. So don't think I'm going all the way with you. All right. But I'm going to work with you a little bit and I'm gonna go back to community. All right. So that's fair. You say community, and people without community do weird things, no matter who they are, where they are, right? To find community. And then you have a need to find where you are in the pack. So you need to hold it down in a certain way to establish yourself within the community and to have yourself solidified in the community. That's natural. That's not just a street thing. That's a natural thing. Okay, I get that. That's as far as I'm gonna go right now, because yeah, society has some dysfunction. Yes, there are some systemic things that could leave young people in desperate need. There are older people who are in desperate need of community. So I'm gonna give you that little bit. But again, go back to what I said, Rhodes, that your butt got a phone. And so your phone still shows you that even if you want community, there are certain ways to exhibit the need and the expression of such that can keep your butt out of prison versus doing stupid stuff for your need of community that can put you in prison or the grave. Holla if you hear me. So you still need to manifest that differently. You still need to approach your life in a certain way, whether there's a deficiency or not. Which one of us doesn't have some kind of deficiency? That still does not give you license to be an idiot. Unless you just love the consequence. But how you gonna love that consequence? Ain't nobody in there. Do they look like they having fun? Oh, really? Ask them. Ask them if that's where they want to be sitting today. If they'd rather have your seat versus that seat. Anybody in that room right now, if had millions, I'm not talking about little Jeff. Anybody else in that room who's a defendant, if they had millions, do you think they wouldn't spend it to get out of there? So what's the point? You doing stupid stuff. So even if you got to the big M, even if you got there, Every one of them cats, ask them, facing 30, 40 years, would you spend everything you had to get out of here on the best attorneys possible to get out of here? And see who say, nah, I must just stay right here. I love it too much. This is the perfect place for me. I love being here. I don't want to go home. Okay. Think this is Shawshank Redemption if you want to. Yeah, Brooks was here. Holla if you hear me. No, these cats want to be home. They want to go home. So I'm asking you out there, why are you? Because you know these cats still posting. They still posting. We just seeing what cats were doing before. Stuff is more now. Even, I mean, this is years ago. Cats are doing more and more every day. Can you imagine how much footage is out there right now? Incriminating footage? Are you ill? Would you think about what you're doing? I'm not advocating to live that lifestyle, but don't be no idiot. Even the law gives you the right to not incriminate yourself. That's just dumb. What kind of stupid movie is that? If you're going to create a movie of your life, make it be an intelligent movie. What kind of crime movie is that when the villain is dumb? That's comedy. If you're going to make a documentary about your life, pick one of these movies where the criminals have some sense. You done seen them too, haven't you? Where there's some organization of strength and power of the mind. How about this? Just don't do it at all. Okay, don't do it at all. That's my best advice, because obviously you slippery and sloppy and I don't even want to talk to you about it. So just don't do it, because you're embarrassing yourself. It's a bad movie you making. Allegedly robbing people or doing something and then posting the stuff. You just, yeah, I don't want to help you with that at all. Just stop. You see what McDonald's is paying nowadays? I ain't joking. You see what McDonald's is paying nowadays, right? Take your butt around there, get you a job, and leave this other stuff alone. Because you giving criminals a bad name. For real. I'm not an attorney, but I don't even want your case. I don't even, seem like job security, right? Like the way y'all keep acting, lawyers don't keep on getting paid. I don't even want it. I wouldn't want you. I don't want your money. You's a dummy. I don't want that kind of money. I want a smart client. These ain't the type of clients I want. Ridiculous. You hurting yourself. Have you told me everything that you've done? No, I forgot. I did post a video. I was driving that car that I stole. Yeah, and then we got drunk and I hit somebody. And I posted the dude laying on the ground that we hit. And then I drove off. But I posted. What? Are you sick? Nah, I ain't representing you. No. Get out of my face with that. And this is what I'm saying, brothers and sisters. Look, I'm fighting for you. I'm trying, we fighting for justice, but you got to stop doing stupid stuff. For real. I'm real, man. I ain't saying it's all even and all fair in society. I'm not saying that. Not at all. Not at all. But doggone it. I mean, you got a mind. God gave you a brain. Use it.
So wearing, you can see his headpiece or the hat or the mask that he has on his head is also another mask that says "Keep America Slime Again," and then he says "This shit YSL" at the end. So,
Okay.
for those reasons, we believe that is relevant.
Anybody want to argue against that?
And just like the first one, I'm not conceding that this is for publication for the public, and I haven't heard how the state is going to lay that type of evidence before the court. And I don't have that evidence, so I can't tell you that it was for publication. I
So
can't
it's a
tell you it was
live-
private.
Okay, we'll circle back on that.
Okay.
I don't know how the state's going to prove that that is the chain that was stolen from Mr. Smith.
I bet it looks like a pretty distinctive chain. Are you gonna have
Crack
somebody
chain.
to identify that as the proceeds of the robbery?
The victim goes by the rap name Trap Commander, and that's what is said on the chain that is stolen. And we intend to call that individual.
Okay.
And then I don't believe that this, depending upon if it's public or not, I don't believe that this furthers a conspiracy, which it has to, the way I understand it, for his verbal statements.
All right. Can you respond to that?
Yes, Your Honor. So in looking at the Instagram return, we know that this video is from the archived live videos.
Okay.
Instagram does not disclose, at least on our immediate review, whether it's a public page, but we know it's a live video. I imagine he is broadcasting it out to someone because it's a live video. He's not broadcasting it to himself. And so a live video is what we discussed earlier. He gets on Instagram and anyone who is following him can literally open up his icon and see that he's doing a live video.
And if you haven't yet, are you gonna present somebody to explain to those of us who are not 20
Yes.
that all of this is true?
Yes, Your Honor. We will
Okay.
have someone explain Instagram for Instagram. And because he is posting a day after the armed robbery, the boldness of stealing the person's chain and with YSL paraphernalia on and saying YSL. For those reasons, we do believe it's in furtherance of the ultimate YSL enterprise conspiracy.
All right, I'm gonna rule.
I was gonna let her get away with that. Y'all tell me, is that a little ageism? Because she doesn't know. So now you gotta be 20 to know about IG. I mean, I know people listening to what we do, whether they're hearing it live or on the replay, they ain't 20 and they know something about how to watch somebody on a live stream. They ain't gotta be 20 to do that. So just because she's acting like she doesn't know, because you know how Paige can be, don't necessarily think she's telling you the truth. Either way, why you gotta be 20 to know how to click on an icon and see it alive? Okay. I mean, it's fair enough to say they should bring somebody in to say how this, that, and works and put it on, as evidence, especially since this stuff possibly going to appeals and, dot your I's, cross your T's. But that little statement about being 20, for those of us that are not 20, skip that. Speak for yourself. That's your way of giving us some kind of blanket when you don't understand something or acting like you understand something. Okay. Well, you are a politician, so we'll keep you in the right light. Sometimes politicians do say things that are not true, don't you know?
Rule that admissible. Yes, when I rule it admissible, I have done the 403 analysis and found that it is not excludable under 403. Nothing in there is substantially more prejudicial than probative.
The next item, number 16, and that's going to be from 53 seconds to 2 minutes and 50. And for the purposes, we'll identify it as the last 4 digits, 5860.
This
And this is
Instagram.
It's also an Instagram video,
live feed.
live feed as well. And this is on October 14th, 2021.
Okay, so 2 days afterwards.
Yes.
Okay.
52 seconds.
Well, hold on now. They locked Slate face up. They did. Oh, everybody did. Yeah, they wound up. You Slate face, man. He said, what? He said, so where you at? You finna be, you still on the way up there? Yeah, we on the way to the room. We on the way to the room right now. Oh. I'm gonna call you. Yeah, all right, motherfuckers. Flat theater, man. Hey, I'm at the studio. You at bullshit? Yeah, I'm gonna lock in right quick. About 4 or 5 hours. You'll be back by the time you're here. Alright. Yeah. Hey, wait. Oh, yeah, slap bit, no rat bit. No kiss. Think somebody add me, please. Where you from? Boy, how the I don't think get all this shit. Hit the phone.
And we can stop it at 2:47, Your Honor. So a few things that occur in this video is Mr. BB is on his way somewhere, and Mr. Eppinger joins the call again or joins the video again. You hear him say, as he's holding up the chain that they just stole a day before, says slap business, and then later again they say slap business, no rat business, Your Honor, and believe that testimony will come out during this portion that Darius Smith had went to the police, after he had gotten robbed. I believe there is some information that he was being threatened after he went to the police.
Okay.
After he went to the police, Your Honor. Furthermore, also in this video, you see another co-conspirator, Miles Farley. When they pan the camera to the individual who's in the front, he appears to be sleeping. That is another co-conspirator in this case, which is Miles Farley. So for those reasons, and you see them also in this video putting up the YSL sign as well, that for those purposes, this is relevant to show association, to show the furtherance of the enterprise, especially even after the armed robbery.
All right.
May I?
Yes.
I am going to wage the same objections, that it does not further the hearsay objection to the conspiracy. But if your court is consistent, then what I'd like you to do is please wrestle with the idea that the one before 3396, showing the court said that's a specific pendant, and therefore it's relevant, and the armed robbery occurred the day before. This is the following day, so 2 days after it. This has the same pendant showing, so I would argue that under 403 at some point it's cumulative. So those are my arguments.
All right. So I think, yes, sir.
Yes, Your Honor. I have a question. As a condition proceeded to the admission of this particular piece of evidence, public or private is a condition in terms of the social media, whether or not the platform was public, correct? Is that what I'm understanding? It's a question.
So you said this was another live feed?
Yes, this is also for archive live videos.
So if they are downloading that information or those documents from a live feed, how do they know at the time that it was public? That's what I'm trying to understand. I want to make
Well,
sure.
and honestly, you may need to have somebody come, like, give a proffer on all of that. I mean, I hear you saying your understanding is that it would only be archived if it was the live feed, and that live feeds stay up for 24 hours. And I think that anybody who wanted to log on to that page could see it, or at least anybody who was a follower could see it.
Definitely anyone who's a follower could see
Okay.
it. And I think that's the distinction. Anyone who's a follower of the person could see it. Whether or not someone who's not a follower could see it would determine whether or not it was a public or private. I don't know if that, to me, that goes to weight, not admissibility of the evidence coming in, whether or not it was a private or public page. But what we know is a live video. Other individuals can see that, whoever may follow him, or if it's a public page, people who don't follow him can see it. But other people besides himself could view the video.
So, I mean, this one is, it's a communication between, and amongst several co-defendants and alleged co-conspirators. Given all that she set forth as the different things that were significant, I don't think it's just cumulative of him himself sitting there with the chain. This is him talking to his,
his co-defendant,
co-perpetrator
yes.
of the robbery, and talking about slat business and rat business. So it's not simply cumulative. It adds a whole lot more. And honestly, like, whether this one is
Right.
public or not,
Okay.
it's them talking in furtherance of the conspiracy. So for this particular one, it wouldn't be significant to the ruling, whether it's public. For that first one, it seemed to be, I mean, for one thing that she was saying, that was one of the reasons why, but, yeah, not really for this one.
And for the court, I'm being told that whenever the court does consider public or private in terms of whether or not it's a condition precedent, that there should be some comments or icons demonstrating how many viewers are present, common.
Okay. So I don't think how many viewers actually see it is significant to the fact that you might be putting it out there to be seen. Or you're putting it out there where it could be seen.
And comments and viewers count are key, to determine or in allowing. I'm just trying to read the writing.
Westmoreland is like, would you older people please stop talking about this?
But Your Honor, the reason why Attorney Matthews is bringing up comments and things of that nature is because when it is public, even just public, meaning that your own followers can see it, you would tend to see commentary from even your own followers.
Okay.
So I just don't think that the state has proven that the videos, at least the videos that you're considering, whether it's public or private, even your own followers being able to see it, I just don't think they provided any evidence of that.
All right, well, I don't think it really matters for this one. So I find this one to be admissible.
Your Honor,
Yes.
before, and this has nothing to do with the court's ruling. I'm not trying to relitigate anything, but
Mhm.
while Ms. Hilton was speaking, she mentioned Mr. Darius Smith and their possible threats or something of that nature. I don't know of anything that I've been told or provided in discovery that provides any information about that. So to the extent that the state's ever going to want to get into anything like that, I would expect to be given some information.
Some production of something.
Yes.
Are y'all planning to get into that?
I believe it's already, and we'll double check, I believe it's something that's already in discovery, that after this, whether it was his interview, whether it was Mr. Smith's interview, that he talked about receiving threats because he went to the police. And so I'll
All
find
right, we'll
specifically.
just
and
make
get it
sure
for you.
that they've got that.
Okay, so there's no video of any threats or
No,
anything like that?
no.
Okay.
Okay, it's just that he says during the course of his interview with police when he was reporting the crime.
Yes.
Okay, and y'all are familiar with that?
I'd have to check too.
Okay,
I just
that's
didn't
fine.
remember seeing any
Okay.
videos or.
Yes.
I know you just said that the last one, which is 5860, has more, so it's not cumulative of the
Mhm.
previous one, 3396, but wouldn't 3396 then
Then be
be?
cumulative.
Yeah, and that's what I was arguing earlier, because you said that it's coming in because it's showing the unique trap commanders, what I believe it says on the pending. I think it says trap
Yeah,
commander.
no, I just thought that when you, that comment was when you said, how do we know it's his necklace? I was
Sure.
saying that looks like a pretty unique necklace.
But wouldn't, I mean, at some point, is it I know it's short, but isn't it cumulative of the next day?
You know, that is much more to me, him really kind of flaunting the necklace that had just been stolen a day before, flashing money, throwing gang signs, saying, if he said, I heard him say this shit YSL, I think that is somewhat different than what we see in that 5860 video.
Your Honor, after all of the,
The
specific-
videos, okay.
Yes, after all of that, I just wanted to make a general, ask the court's instruction on a general matter about
Okay.
cumulative nature, but I'll let the court go through all of this. I just didn't want to.
Well, what do you want to know?
Generally, what I'm hearing is that whenever a video, a picture of something is shown that's slightly similar in nature to something else, there's been the cumulative of the 403
Mhm.
objection. And the court knows, and everyone does, that there are 65 counts in this indictment and 8 defendants currently on
Mhm.
trial. And to the extent that some of the evidence in the court has been essentially ruling along these lines, but I just wanted to say that to the extent that there are efforts by the state to put in multiple showings of a defendant doing, or other defendants or co-conspirators doing things that may appear similar on different times or at different days, this is meant to rebut this continued assertion by counsels for 8 defendants on trial that this is a record label and nothing more. So I just wanted to put out there regarding the cumulative and the 403 objection that we constantly get when there's some similar, and the court's ruled the way, I believe that is proper, but I did want to respond to that objection that is constantly being made. Thank you, Judge.
Well,
Your Honor.
to me, cumulative isn't whether there's some reason to put it in to rebut something or not. It's just do 7 or 8 different pieces of evidence show the same thing. Then after like probably 2 or 3, 4 through 8 become cumulative. So you're not necessarily limited to, oh, I can only show this one way with one piece of evidence, but you don't need to show the same thing 8 different ways.
Well, Your Honor,
Yes.
Ms. Love's argument may remain the same, but it's not 8 defendants, it's 6. It's okay.
You're right.
Right,
I
I found,
suspect your argument would remain the same.
I found where we were referencing at least some indication that maybe the victim in the armed robbery was being threatened.
Okay.
It's going to be in Discovery 7. And within Discovery 7, the last police report, it's the first paragraph
Okay.
from May 18, 2022. And then the actual text messages that is referenced in that particular portion of the police report is also found in that same folder, in the digital evidence folder.
Okay.
You're welcome.
All right, when do you think we all can circle back on the evidence that y'all were gonna get together on with regard to Mr. Ryan?
Mr. Boston, right before the court came out, we were trying to figure out a time, so we'll talk some more after lunch. I mean, after lunch, at the end of the day, just
Okay.
to try to solidify a time within the
Okay.
next couple of
I'm
days.
just not sure we're gonna have a non-jury day before y'all might get to that. I mean, we might, but. Okay, so I have some notations on, if we go back to, I guess it must have been on this wiretap, because that's what we've been going through.
Your Honor, you did ask the state to look at least, before we get to Mr. Harvey's motion, you had notes on 2 of the recordings.
Okay.
I believe it was what was identified as 513
Yes.
and /523,
Right.
and then 1109 and 1124. I'll start with the easier one, Your Honor. 1109, 1124, the state does not intend to use.
That does make that easy.
And then I'm not sure if the court just wanted for 513 to 523, the relevant portions of that call.
So on that one. It was the part, yeah, the flipping the car and laughing part.
So when I listen to it, I don't know if I hear flipping the car, but there is some conversation that starts at about 35 seconds into the call, in which, to set the stage, this call is at about 9:45 p.m. on March 16th. And so this is about 9. The home or the house at 2830 Waters Road just got shot up earlier, late the night before, earlier in that day. And Mr. Garlington is speaking to someone that we believe to be Dewaskin Wright, who is a member of 30 Deep. And when they're on the call, they first talk about different types of weed.
Yeah, I said that part then.
And after that, Demekion begins to tell Dewaskin about the drive-by shooting. And he tells them that 12 had us, they shot up Big Nick's spot, which is the home where they are. And we thought that they were going to come back through, meaning that they thought that the ops were going to come back through, that they sprayed through the house, that they were all in the living room, and they're surprised that no one got hit. And Dewaskin asked, well, essentially, why do you think it happened? And Mr. Garlington says, one of their little partners just got shot or just got killed in Mechanicsville, which would have happened on March 14th, 2 days prior. Then at some point in time, a little later within that call, Mr. Wright says, do y'all have a drop on them in words? And Demekion responds, I would need to play it again, what exactly his language was after response to that. And that portion from 0:35 to 1:40, and then from 1:48 to 2:31. There's a small 8 seconds in there that we wouldn't need to play, but those are the two we believe relevant portions. Again, they're talking about the opposition first shooting up the place and then being asked by a 30 Deep member who we allege they have alliances with, YSL, that some members who were formerly 30 Deep are YSL, and then they still have an alliance with 30 Deep. He then asked, do you have a drop on them? Meaning, are y'all going to retaliate is what we would think that they say. And those are the portions that we believe are relevant. Your Honor.
And those are the only portions of that.
Yeah, the call is only 2 minutes and 30 seconds. So it's really the entirety of the call, except for that 8 seconds that
Okay.
is between 40 and 48. Yes, sir.
Yes.
There's a portion, I believe it's the same call. So I have it as call 513. Mr. Shark gave me that number.
Yeah.
That it says something to the effect, and I was going to object. It says something about McMiller's funeral is going to be private, and his mother doesn't want Thug there or his money. And I don't see how that should come in. That would be a hearsay statement. I don't see how that furthers a conspiracy. If it's not on that call, then I have the wrong number. I have 513.
It's not that call. No. Well, let me make sure.
Well,
Hold
I
on.
think it is.
No, I'm sorry.
Well, it may not be. I don't know.
So
No,
there's
no,
two
no, no.
reference, remember, there's a page number and a reference number. I'm
Right.
with Mr. Steele. I have 513, and I think we're going by the call reference number.
On the sheet.
So the
Or
call
no.
reference number for 513 is the call that I'm just speaking of, which is on March
They came
16th.
through and they were gonna come back.
It's-
Yes.
Getting ready to
I have
write
the
them
same
up.
date as well. You're on
Okay.
5/3/16.
What time on March?
So the call,
9:41.
9:41. But we can listen to the call, but I just listened to it and I don't hear
We're not
anything
gonna
about.
play it. If it's not an issue, there's nothing to discuss. But if it is an issue, I wanted to raise it.
Okay, because part of it, when it was described on this big sheet that y'all shared with everybody, was them laughing about the drinks murder.
Right. And I have that happening at 4 minutes and 20 seconds into the call. So, and I'm not saying Ms. Hilton's wrong. Maybe this call isn't that long, but the parts that you wish to play, can we just play it?
Yeah.
Because there's a lot of confusion.
Okay, because then I guess the part about the drugs comes after all of this. Okay, all right. Because I definitely wrote down that there was something about, y'all said there was a non-hearsay purpose and you wanted to show something about flipping the car and laughing, but if y'all aren't gonna get into that anymore, then that's fine. And I think this one and the one before reference a quay, and understandably, there's some concern about confusion. Is it gonna be clear? Mm-hmm.
And I'll apologize. I must have listened to 512, which is the 2 minute and 40-second call, because they talk about drugs in that call as well. But it looks like I was supposed to look at the call under.
The one at 9:41 p.m.
Yeah. Of course, indulgence for one moment. Let me just-
No, that's the 502 is also 512, and that's talking about Big Nick's. And that one also says something about not having a drop on people. But we ruled that one, or I ruled that one could come in, but there was a concern about whether we need a 105 with regard to Quay or Qua, which I'm happy to consider.
On call at lunch, I listened to the 2 minutes and 40-second call, which is the call right above it. If we could have a.
The one that says 502?
Yes, Your Honor, at 6:49. If I could have a brief moment, I can listen to the correct call, Your Honor, for that. I
Well, we-
apologize.
Okay.
Talk about the same thing twice.
Only other one we had talked about but not made a decision on was the nested hearsay one. Do we need a quick break? Why don't we all take a quick break? 10 minutes.
I'd just like to recap if we can before Ms. Hilton. Can we recap where we are just for a second?
Sure.
You
And there
can
she
help me
is.
with that, please, Judge. My note from our previous sessions said 513 was open, 624 was open, 806 was open. The state today said 1109, and I'm going from the reference numbers.
All right, hang
They weren't going to try to get that in. Was there a ruling on 513?
That's what she needed to go back and
Okay.
listen to again. So that's what we're about to hear from her, whether she's narrowed.
Okay, great.
And then, okay, so read those out to me again.
All right, 513 we're going to deal with right now.
Yep.
624. I had that, my notes reflect that that was open as well.
What,
Open meaning you hadn't ruled
we
on
have
it.
a,
Yeah.
yes, agreed. That's the one that's the nested hearsay, right?
No, the nested hearsay, well,
Oh, okay.
it, nested hearsay was 2119, that's on the next page.
Okay.
At least that's the one that,
Yeah, you're right.
so I'm trying to
So
figure
what
out.
else? So 513 /
624,
6, which is also 635. It's very complicated with
yes,
these two different numbers.
806 and 820.
806, yeah,
I had,
you're right. I have a note by both of those that said
So there's no-
tomorrow, which we apparently never
Right.
got to that
so
tomorrow.
there's no ruling on those yet?
Correct, no
Okay.
ruling yet. And on both of those, if somebody from the state could listen, I think the question for both 636, I don't know which reference number's which, but 624 / 635 and then 806 / 820, I think, was who is the other talker? That's what we were waiting to hear back on. But yes, that matches up with what I've got as well, Mr. Harvey. All right, so if you're ready on the 513, 523 one, we can do that one.
So I can answer the 624 and 806.
Okay.
We just know right now there's a person named Onk, but we don't know who that person is.
Okay. Named, what's the first name?
Unk, like they call him
Unk, okay, which y'all knew also, and they don't know who that is. And so are y'all asserting that Unk is a co-conspirator, or you have no idea?
No, we're not going to circle. We don't know who.
Okay,
Unk is.
and so then, is there some other basis under which you're asserting those two, whatever they are, conversations could come in? Okay.
No, 624, 806.
Getting to sorting through the evidence exhibits today.
And also, Judge, while the state is discussing
Sure.
among themselves, I think that's almost as far as we got.
It is, because we stopped with, I mean, we got much further, but we stopped with the one that is 2119, that
Right,
is
that's-
that nested hearsay.
Yes, that's what I mean.
Yeah.
And then there's a page
That's
and
as
a,
far as we
there's a
got.
page and a half.
I know,
Okay,
after that.
yes, that's,
Yeah, no, there are many, many pages after that. 3 pages after that.
Judge, forgive me for missing the portions of the conversation that Mr. Harvey was just having. I was looking with my colleagues at number 624 and 806. Are we correct that those are the two that the court is now inquiring about?
Ye- As to, yes, Unk,
513 and 513.
no, we're not, we're gonna come back to
Okay,
that one.
all right, sorry.
Okay.
That's-
So,
Go ahead, sorry.
so, Your Honor, in advising the person that he calls Unk about the search warrant at Waters Road and Ms. V being on him, one, and I'm not yet through in saying this, but one, the familiarity of the person to whom Mr. Garlington is speaking with Ms. V, and without further explanation as to what Ms. V being on him means, it becomes apparent that this is a person who is aware that at the time Investigator Vivarito is someone who has been, who's had Demekion Garlington on his radar. So Demekion Garlington obviously is talking to someone that he trusts. But the 806 call where Demekion Garlington is telling the call Unk that he said on the news they got 2 and 1 outstanding warrant. They just hadn't said my name. He just wanted to make sure he didn't know what was going on. You've made it back, okay. And the person advising him to keep it to your chest, and that Mr. Garlington is advising that person that he's trying to make as much as he can now. These words all lead us to conclude that this person, though we don't know his identity, he is a person on whom Damikian Garlington is relying, who he is getting support and advice from, as it relates specifically to the conspiracy, arguably in telling Mr. Garlington to keep these matters to his chest, this person that he's talking to knows all about Waters Road, knows what it's there for, knows that likely knows about what was being kept at Waters Road, given that he's not asking, wait, what do you mean? What about Waters Road? Who is Miss V? So this could be, though we don't know, and we're not trying to assert that this is some person we know is, YSL. This seems like, reads like, he listens like an unindicted co-conspirator, someone that he is relying on and trusting for information and guidance as it relates to his actions in this conspiracy. Those type of actions fall under what courts have deemed statements in furtherance of the conspiracy may consist of. Because of that, because of the type of information he's sharing and the feedback he's getting and the role that this person seems to serve in Mr. Garlington's life, these two statements, we'd argue, would fall up under the co-conspirator statement exception.
All right. Does anybody need to hear them again?
I don't know. It seems to me that if we don't know who this person is, I don't know. My understanding of the case law, and I don't have it, but I'm certain of it being the law. I can get a case, is the statement itself cannot establish the conspiracy and the prerequisites of 801 D2E. So without knowing who the people involved in the conversation are, and just going by the conversation itself, I don't know if that ever, I do know that could never satisfy the requirements of 801 D2E under our Supreme Court precedent and state in case law in Georgia as well.
What do you say to that?
I do not agree with that assessment at all. In 502, this is an 11th Circuit case, but United States versus Miles 290 F3D 1341 is from 2002. The courts have said in its admissibility evaluation, the court may consider the statement itself as well as extrinsic evidence to qualify. The statement need not be necessary. This is not what Mr. Sharp was putting forth, but it's, I think, helpful.
It's exactly what I just said.
The statement need not be necessary to the conspiracy, but needs only to somehow further the interests of the conspiracy, Your Honor. And personal knowledge of the subject matter on the part of the declarant isn't required, but it talks about the statements of unindicted co-conspirators. Specifically, Your Honor, I think
all right, we know statements of unindicted co-conspirators can come in if they otherwise qualify. What Mr. Shard is saying is the conspiracy and it being in furtherance can't be established by this statement alone. Is that what you're saying?
Correct, Your Honor.
I haven't seen.
Can't bootstrap itself, and I'll get you.
So Your Honor,
he'll get us a case.
So
and we'll take it up.
I'm reading from
the statute.
Yes, it is. The statement must be considered, but does not by itself establish the declarant's authority.
Your Honor,
under the existence or scope of the relationship or the existence of the conspiracy or participation in it.
Your Honor, I'm reading from United States versus Rivera,
Okay, I'm reading from the
Hang
statute.
on, don't talk at the same time. Let me pull up the statute. That would certainly be the easiest place to go to if it answers the question.
And I have cases, Your Honor, as
All
well.
right. Give me a second. As the contents of the statement shall not alone be sufficient to establish the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered.
And so, Your Honor, the state is not tendering the statement. We in no way suggest that the content of this statement alone establishes a conspiracy. The conspiracy, we'd argue, has been shown by evidence that we've already presented at trial and more evidence that we will be presenting later on. What the content of the statement does show is that the unknown party to whom Mr. Garlington is speaking about things that the conspiracy inherently kind of involves, i.e. Waters Road, Ms. V looking for him, the outstanding warrants, all of those things that sort of the conspiracy encapsulate. When he does that, he is receiving, he's giving the statements and he is receiving assurance, and the statements made between the two are serving to maintain trust and cohesiveness among them, or inform of the current status of the conspiracy, which furthers the ends of the conspiracy, so long as the other requirements of 801D2E are met. And that's coming from a First Circuit 2012 case, United States versus Rivera, RIVERA-DONATE at 682 F3rd 120. Especially when you hear, given everything Mr. Garlington is saying, I mean, he's literally just telling the guy, like, you know, Ms. B is on me, blah, 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 blah. And of course, the court and anyone can listen to it. But he just wanted to make sure, you know, he didn't know what's going on. You made it back okay. The man is saying, keep it to your keep it close to your chest. And Demikian is then saying, I'm trying to make as much as I can now. This particular case that I'm about to point out is a Third Circuit Court of Appeals case. So it's not anything that the court has to follow. It's just sort of instructive, but it does speak to the United States versus Lignelli, Lignelli. And the site is 660 Fed APPX 118. It's a 2016 case. There, the court found that a statement made by an unknown speaker could qualify for the co-conspirator exception if the government establishes that the speaker was likely a member of the conspiracy alleged. And in United States versus Helmel, which is an 8th Circuit 1985 case, and Helmel is spelled HELMEL. and that site is 769 F2D 1306 at 1313. What Lignelli says or cites Helmo for is the parenthetical. What is essential is that the government show that the unknown declarant was more likely than not a co-conspirator. And I believe that the prescriptions that were described earlier regarding the statute alone, the statement alone being used to establish a conspiracy is
Right.
not one applicable here.
Okay. All right, can I hear the statement again? It's been a while since I've heard it. Yeah.
Just so that the court is aware, since we are researching in real time, there's a notice at the front of Lignelli that says not presidential opinion under Third Circuit Internal Operating Procedure Rule 5.7. Such opinions are not regarded as precedents which bind the court. I want to make the court aware of that notice.
Black. What's going on? Where you at? In the apartment. You got your family? Hell nah. Nah, I got shit. Just got down West End. So no folk got down. Where the hell you at? I finna pull up. The meet on White out there. Yeah. Nah, everybody out here though. I ain't got no fly. I been got the chillin' to these folks home. You said you trying to do what? I said I just been chilling trying to see what these folks on before I get them up. What? Yeah, man, fuck you. Nah, cause them folks they got damn man. That shit, them folks they hit the spot that they went and then I was still just like what Miss V, boy. I know they hit that bitch. Yeah, but now I just feel like Miss V on a nigga, boy. So I'm just trying to move cautious. Well, definitely. You doing that wrong. Yeah. And she saying, yeah, I see nothing. Well, you know she on y'all. Who else you say out there? Big regular, big, zoo them. Big out there? Yeah. All right, here I come. All right. Yeah.
Your Honor, I'd also point out a thing I left out. The person to whom he's speaking is also advising Mr. Garlington, giving him more information about the circumstances out there that Mr. Garlington was describing at Waters Road, where he's talking about who all else is still out there. So that adds to our argument as well.
All right. Let me hear the next one, if you don't mind. Yes.
Hello? Hello? What going on? What's up? Hey, what's up with you? What happened? What is that? That, my bad, no, look. I just seen the news. I seen the news, they said the two they got, and they said the one they got on, outstanding one, they ain't say the name. Oh, okay. Yeah, well, I just feel. Well, I just want to make sure I don't know what's going on. Yeah, you know I'm back though. I just really let you know too. I was back. Yeah, you don't made it back. Yeah. Okay. Yeah. Well, shit. You just keep that shit can't really hold on to that paper. Yeah, that's what I'm doing. I'm just trying to make as much as I can, Yeah. Exactly. Right down I'm here though. I'm gonna let you pull up on me. Check out down answer the phone. All right.
And if the court notices, I think Mr. Garlington does not even start giving details until he's reassured that it's Unc, who of course then tells them, you just keep that close to your chest, and so forth. So I think that both of these calls make it apparent that this person is giving information that serves to reinforce the underlying purposes of the conspiracy itself. They're providing reassurance. They're informing of what's going on, that is putting members of YSL in peril. Ms. V out there looking for Mr. Garlington. He knows who she is. So we believe that these all form to tell the court these are statements of co-conspirators that should be admitted. And yes.
I'll hear any defense argument. And Mr. Sharp, I think with regard to, and Mr. Harvey, the issue of the statement alone can't establish the participation of the declarant. I think with regard to Garlington, there's certainly more. And are y'all offering like both sides of the conversation?
In order that they understand what's going on, yes, both sides are being offered of the conversation. The most important part we feel is what Mr. Garlington is saying. His words are more pertinent because they're reflecting a knowledge of something that just took place. Is very important and close in time to acts that are alleged via overt acts or counts on this indictment. So Mr. Garlington's words are the most important ones, but the other ones are needed for context.
Can I just respond very briefly to this? It's still just the statement itself. And every court, the United States Supreme Court and our Supreme Court, have specifically said in determining the existence of the admissibility of a co-conspirator statement, the trial court may consider both the co-conspirator statements and independent external evidence, although the co-conspirator statement alone does not suffice. That's specific language from Dublin versus the state at 302 Georgia 60, pinpoint site 63. But that's the rule, and that's the intent of the rule in the code. I have heard nothing but argument about the statement itself, but no external evidence other than the statement itself. And that is simply not enough with an unidentified party,
right?
Period.
Yeah, so I think with regard to whomever Unc is, that it does sound like all you're relying on to establish that Unc is a co-conspirator, and therefore the jury can consider what Unc is saying is what he's saying and what he seems to know that's based in the statement itself. So I think that if this comes in, if these two come in, there needs to be an instruction that, you know, it's only Garlington's statements that you can consider.
In his, hang on, I'm sorry. In as much as Unks is providing context to what Garlington's statements are, one moment, Your Honor, I'm reading a statute. If the court would indulge me, I apologize.
Your Honor, if I may jump in, I just have actually a couple cases that could maybe.
All right, can you wait just a second? Because I think Ms. Love's trying to absorb the statute right now.
Almost, Judge. I apologize.
Okay.
Making sure that I'm reading the right area. It's the portion of the statute that says the contents of the statement shall be considered, but not alone sufficient to establish a declarator's authority under paragraph C, which is not applicable here
Right.
because we're not talking about
D
that.
is not applicable, and then, yeah.
Or the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered under subparagraph E.
Right.
So if I'm reading this last portion that Mr. Harvey references, we're not trying to establish both
The existence of the conspiracy, right.
Right.
That part's not the issue.
and the participation therein against the declarant.
That declarant being Unc. The Garlington statements are one thing. I mean, y'all have other evidence that Garlington is a member of this conspiracy, but you don't appear to have others for Unc.
So it's not, and I hesitate to say it, but it's not so much Unc's statements that are important. Unc's
Right.
statements are the ones that give context to Garlington's statements. And so to the extent that you need to hear what Unc is saying so that you know what Garlington is responding to. That part is important. So to the extent that I guess an instruction that statement, you can consider them for context for Garlington's statement. I mean, I'd have to work through that, but
Alright.
my reading of it is that the declarant of concern is Garlington, and we're not really that concerned about Aunt.
Well, you might not be that
I know
concerned
that.
about,
I know that.
but if the jury's gonna hear it all, then why don't you look at both of those portions again and see if there's some way, if it's Garlington's that you need, to have just Garlington statements come in, and if not, what limiting instruction would be appropriate?
I appreciate that opportunity. We will. Thank you.
All right.
And Your Honor, I was never able to verbalize, maybe for the record, maybe to persuade the court,
Okay.
about why I didn't believe that Garlington's statements were admissible under 801 D2E.
Okay.
My argument, I think the fact that we don't know who Unc is important, because certainly knowing who the receiver is, knowing who Garlington is speaking to, would better educate us as far as whether his statements are in fact in furtherance of a conspiracy or not. And at least the second call, he seems to be calling Unc and just saying, hey, I heard I have a warrant. You know, what should I do? And Unc seems to say, you know, just stay safe and get money ready for a lawyer. But it seems that Garlington is concerned about his own legal troubles or the possibility of being charged. I don't really find that as furthering any conspiracy. That seems to be concerns about himself and his legal future and and concerns about being incarcerated. But I don't view that in any way, shape, or form as furthering any conspiracy. And especially since we don't even know who Unc is. But you know, me calling, if I was involved in a conspiracy, and me calling my literal uncle, who I reach out to for advice, and him saying, hey, Max, if you think there's a warrant, you know, start getting your money ready for a lawyer and, you know, stay in the house. I don't know how me asking my uncle for advice would be furthering any conspiracy. So I don't believe that Garlington's statements, at least with that second call, meet the requirements of 801 D2E.
Yeah, I think that Mr. Sharp's analysis leaves out, if I'm mistaken, forgive me, and he can correct me. I think it leaves out Aunt telling him what's going on at Waters Road, like who else is still out there in that second call. So he's informing him of circumstances that still exist that put members of YSL who incidentally were hiding in and then ran from and apparently took contraband from. And this is our assertion that we believe the evidence will show. So I'm not trying to put something in front of the court that, you know, is just my word is bond. But Unc is advising Garlington about circumstances that continue to place YSL members in peril. And Unc obviously has knowledge of what this conspiracy is. He's not asking any kind of questions.
And,
So,
and then
well-
Garlington's responding, he's wanting to make sure what's going on and is
Right.
told to keep it to your chest. And frankly, he doesn't need to be talking to a co-conspirator.
I agree.
Okay.
I
And
agree, but I still think knowledge of who he's speaking to,
would certainly,
Right.
sure,
and
further elucidate things for us, but it's not necessary for the admissibility of this statement. I mean, this, I think, would come in under, I can't remember the name of the case right now, but the case that's, I think the state cited where, you know, somebody's getting support from their girlfriend or something about, you know, how to handle the fact that somebody might be on to them. And it's not exactly the same, but it does sound like, frankly, it sounds like this is somebody who knows a whole lot about what's going on at Waters Road, and they're sharing information in order to stay hidden. I don't think.
Respectfully, so this is the day after the Waters Road shooting. So this is not while Waters Road is in practice. And he says, I'm pulling up. And I think a very common sense reading of what was said there is he's pulling up to where Unk is and wants to know who's at Unk's house. The state keeps saying, alerting about who's at Waters Road. That's not the way I hear that call at all.
Your Honor, the court should also be aware that this is the day that police go to search Waters Road. And I think in another call that the court heard on our previous hearing, they find that the sticks were removed, like they took guns and stuff out of the Waters Road the night that they were there initially just to check on the occupants, and nobody was willing to come to the door, but they found everybody hiding in cubby holes and stuff. And so in subsequent calls, I think the court heard last time that they didn't get the sticks that were in the attic or wherever it was. And now Unk is talking about, my reading or listening to it, Unk is talking about who's still around, and Mr. Garlington is talking about Miss B.
I think whether he's saying who's still at Waters Road or who's at wherever he's about to pull up to.
I just want to make it clear for the record. This is not the day, to my understanding, that Waters Road was searched, okay? And the state, I would love to hear their evidence, whoever Unk is, that he was at Waters Road on that day, because it doesn't exist. He's talking about where Unk is, and I'm pulling up to you, and who's over at the house, which is not furthering any conspiracy. But, I understand the court's ruling, and I just want to state that for the record.
All right, thank you.
Your Honor?
Yes.
I did just want to bring attention to one case. This, I don't know, perhaps frames it in a bit different way. Statements are admissible when the state establishes a prima facie case of conspiracy independent of the co-conspirator statement. I think looking at this, if we look directly at that standard, let's take out what the statement is. What evidence is there to make a prima facie case? And the case I'm relying on for that is Williams versus State, 293 Georgia, 750 from 2013. There's another case which quotes the same language. It's Newer Franklin versus State, 298 Georgia, 636, 2016. And in both of those, they go on to discuss some of the other independent, separate, apart from the statement evidence, which did justify using that co-conspirator exception. But here, where we have no information about Unk except his name is Unk, I don't think the state can make that prima facie showing.
I don't either. I mean, I think that with regard to Unk, there's not enough. So that's why I've directed Ms. Love to figure out whether she can either get in the Garlington statements without Unk's statements, or if not, come up with some appropriate limiting instruction.
And we can do that, Your Honor. And just as a matter of the prima facie showing of the conspiracy itself.
Yeah, no,
we're not dealing with that.
I get that. And there's enough to show that Garlington is a co-conspirator and that there's a conspiracy. This
Thank
is
you,
just
Judge.
with regard to Unk, as far as I'm concerned. So let me write myself a note. And then we'll circle back to the 513, 523 one.
Thank you, Judge. In this case that Ms. Abbasi just cited, does the court mind providing that site one more time?
Franklin or Williams, or both?
Both, please, if the court doesn't mind.
Franklin versus State. Franklin versus State, 298 Georgia, 636 from 2016. And Williams, 293 Georgia, 750 from 2013.
Thank you. And I think that the court already has Kemp.
I do, thank you. All right, let's go back to the 513, 523 or whatever it was, one. So the narrowed version, that's what you were gonna do, was figure out.
So it appears the narrow version is going to be from roughly 34 seconds. Yeah, there's about 3 sections around, so I'll play. The first will be from 34 to 354.
I don't need to hear the drug part again. We already rolled on that.
I believe we're past the drug part.
What, Friday?
Fucking free.
Last
Night, well, you know, I wasn't even gonna come out. Man,
Yeah.
you like that now, pull up. We're finna be on one. Now,
So y'all was in there?
and boy, about 6, 7 deep. Toont, man, Toont, they had them pulled out, boy.
Damn, that's some food. I thought they already went over there and shot one
They
upside.
did, but still, man, I'm on some everyday
They
shit.
double
Yeah.
back.
Oh, you talking about
Oh, yes.
right?
Yeah.
Ain't nobody went next, right?
Oh, no, I heard it a couple days ago, somebody, they said they went over there.
Oh,
That one ain't
yeah,
no.
no,
What you
yeah,
said?
no.
You said they just went over there last night.
Yeah, well, we there, man. I'm like, yeah, man, boy, I wasn't even finna come over here, man.
Yeah, you talking about, yeah, I ain't even know nothing about this
Yeah,
shit.
then look, we like here. We think we like, all right, they gonna come back through. Man, we think they gonna come back through so we can hit that motherfucker up, man. 12 pull up, man. Hey, what?
In the house?
Yeah, I'm like, yo, we hit them folk like, cause we got our lights out. Them folk like, we gonna have to come in. We gonna have to come in. You goddamn. Make sure ain't nobody dead, man. I hit the back door like, hey, boy, I'm on parole, man. All this shit in here, man.
Hey, you talking about,
Hey.
y'all don't have to come in.
Yeah, no, we just heard him talk to the other officer, like, yeah, we can go in, make sure ain't nobody. Man, it be them up under the house. Goddamn, man, but 4 of us in the house, they keep saying, man, you don't go out. I'm like, man, I got me fucked up, man.
You took out right?
No, I hit the back door. Them folks it was on both sides. And I was just like, I seen them on one side, 'cause I was just gonna sit in the car, in the yard.
Yeah.
But I seen them looking at the cars over there, go through the other way. They know they was over there. I feel like, hey, come here. I'm like, hey, man, I just heard some gunshot. Yeah,
you
I'm like,
say?
hey, I just heard a gunshot, man.
Okay.
Yeah, that's like, where you coming from? Like the wood, I'm dry here. It pouring down rain. No folks like, man, you ain't wet at all, man. I'm like, man, I'm telling, man. I was in the woods. I don't know how I ain't wet. I was in the woods. But I ain't no savage.
Man, what?
Y'all check that out, man. I went in there, boy.
Hell no, I ain't got nothing to do with
They
that
still
house.
went in there, though. They checked that. That was good, boy. It be safe.
Oh, they ain't certain.
They'll make sure.
They just looked
They'll
around.
make sure nobody dead.
Yeah, so when nobody know when they went in?
Yeah. They found now. Goddamn, look Quay and another name.
Okay.
Yeah. I'm like, yo.
What they at the house?
Yeah. I'm finna pop out for Colt on her. Colt note. So they got a little video shoot.
And we'll stop it here. We'll fast forward to the next relevant portion. And we'll say, Your Honor, Little Quay is not either Mr. Nichols or Mr. Huey. That is Quatez Arnold, who was at the house during the shooting.
Are y'all gonna stop and tell the jury that?
That will come out. through Investigator Viverito, who was all in the house prior to this call coming in, because Investigator Viverito will testify as to who was there when it occurred. But we've always established, even when we did the motions hearing, who was at the home, and it was never Mr. Dewey or Mr. Arnold. And so that will come out.
Well, couldn't you just stop it 3 seconds before that little quake part gets said?
Right, and we can either remove it, or we can do a stipulation so that it can be, so the jury can hear it in real time, so that the jury doesn't develop.
Okay.
Yeah, because I mean, Viverito may not be coming till sometime later.
What this call is coming in through Viverito. So none of this.
Regardless, I think it's stipulation.
Yeah.
This is not either of these people that are on trial would
We'll cover
be
that.
safer than, if you can either do that or you can take that part out.
Yes, we can do the stipulation and ask her. And I mean, we all agree that it's not either of these individuals.
I have a solution.
Don't play it.
Don't play it at all.
Yes,
But
because
it's a pretty little quick.
it's two parties giggling and laughing about what happened at a prior event. There's no informing anyone for any purposes
I
of
know,
further any
I-
conspiracy. It's just spilling the beans
Your Honor,
and
and
giggling.
I would say though that Quatez Arnold is important because that individual is in a previous video that we have with Quarmavius Nichols that's already in evidence with Quarmavius Nichols.
But just
You're gonna
because
have
something's
Viverito
important, just because
testify
something
as to who all was at that house, right? Right? Hello? I'm sorry. You are gonna have the detective testify to that person being at the house anyway?
Yes.
I mean, I didn't hear anything in this portion of the conversation that does sound like anything other than, man, can you believe what happened? So this portion is out. Yes,
So it'll be out, Judge.
I know, I hadn't listened to that other portion yet.
No, I mean, she was on the cusp of addressing Mr. Sharp's concerns and was wanting to make sure the court knew who was in the house, but she had another argument she wanted to make.
That explains.
Thank you, Your Honor. Yes, Your Honor. So when you hear this portion of the call, Your Honor, they are boasting and bragging about what happened in that home.
Well, sounds like love showed that teamwork. Okay, unless we missed something. I don't want to be too quick giving no praise to love, you know. It sound like Miss Hilton was interrupted and deserved the right to finish. Sounds like Miss Love said, "Hey, wait a minute, Paige. Look at here, Paige. We ain't done with you yet." The woman was talking. Something like that, maybe. Let's see.
Conversation that does sound like anything other than, man, can you believe what happened? So this portion is out. Yes,
So it'll be out, Judge.
I know, I hadn't listened to that other portion yet.
No, I mean, she was on the cusp of addressing Mr. Sharp's concerns and was wanting to make sure the court knew who was in the house, but she had another argument she wanted to make.
All right, shout out to Love. Let's hear from Sister Simone. Walk your talk.
That explains.
Thank you, Your Honor. Yes, Your Honor. So when you hear this portion of the call, Your Honor, they are boasting and bragging about what happened in that home, the fact that they were hiding from the police, or he was hiding from the police with the other members in the house. We believe that was stated to obtain confidence between co-conspirators. We do believe that this person is the Waskin White, who I mentioned earlier.
All right, well, nonetheless, it's out. Let me listen to the next part.
The next portion starts at 4:18, Your Honor. Start a little bit earlier.
Too much going on, oh yeah, they got to see what's going. They flipped nigga get up on the bridge in the Ville.
Yeah, I heard.
Yeah.
Yeah, I heard. Where the hell you at?
I'm right here.
So, Your Honor, that's when they say they flipped
Right.
under the bridge under burden. We believe that they are referencing and laughing about Shamel Drinks because he's just got killed under the bridge, which would be the I-20 bridge in Mechanicsville 2 days before this phone call.
Okay, and you had said before that you had some non-hearsay purpose for it, that wasn't even hearsay, that you, I mean, I don't know what it was, but you said that there was some non-hearsay purpose to introduce that, so that it didn't need to come in under an exception.
Here.
I don't know, I wrote it down, I don't know what it was.
I got it. Your Honor, we believe that the fact that they are speaking in code and laughing about this particular murder when they say, I heard someone flip the car in Mechanicsville, and then there's like a pause, and then they both laugh. Given that this is again 2 days after the murder of Mr. Drinks, and we believe that Mr. Garlington was a part of that homicide, the fact that they are laughing about that particular instance at that time is a non-hearsay purpose of why this portion of the call will come in.
I'm gonna exclude that. So that drug part that we talked about before is the only part of this conversation that is gonna come in.
And there's one more portion, Your Honor, this is the portion that Mr. Steele referenced earlier today.
Oh yeah, they were like, they said your mom like, well, she only wanted to come.
Yeah, they said she only want in the car.
Yeah, I already told them for but folks family gonna be talking crazy anyway. Like they gonna be like, we don't want no money, nothing. Like they gonna be tripping.
Yeah, you know how.
That's how this shit be, yeah.
Yeah. All right, damn.
That's why I know he just like, man, he just respect it. He just know how this shit is.
Yeah.
Yeah. I never said what the hell you had going on. I'm just chilling.
I'm pull up on you like tonight or tomorrow or something.
And Your Honor, that portion is Mr. Wright and Mr. Garlington speaking of the murder or the funeral of Christian McMiller, and it's Christian McMiller's funeral, and that Mr. McMiller's mother did not want Mr. Williams to be present at the funeral. We do think that that is relevant, given that we believe that Mr. McMiller, Mr. Ford's murder was a direct result of Mr. Bennett being stabbed in the jail. And we do believe that the evidence, we believe, will show that the stabbing at the jail was done at the permission of Mr. Williams. So it was a trickle down effect. So we believe that Mr. Jaden Myrick, who actually stabbed Mr. Bennett, asked for permission through Demekion Garlington to Mr. Williams to get permission to do that stabbing. That stabbing occurred once that stabbing occurred at the jail, and the information was released to the public on early in March, on March 2nd or March 3rd. Only about 7 days later was Mr. Ford and Mr. McMiller murdered by YF and Associates, and then the other murder happens with Mr. Drinks after that, Your Honor. And so the fact that Mr. McMiller's mother does not want Mr. Williams at the funeral, I believe, is relevant to show that there is a belief that he is the cause of the murder of Mr. McMiller and Mr. Ford.
And Your Honor,
I
in
didn't-
addition to that, I see the question, he said, I'll be quick, but Judge, the fact that he is bragging about, what we believe to be the murder, and that he is informing the person that, he is talking to, that they were gonna, come back and they were getting ready to light them up, we believe falls under,
That in that clip.
So
It
the part
was-
about
That part is
the
fine.
funeral
Oh,
is
the
definitely
funeral
out.
is not-
If there's some other part where somebody.
That's the first part, Your Honor, I think is coming in, that you allowed to, my understanding is everything from the drugs to everything before Little Quay can come in, when we talk about what it,
No,
or,
no, nothing from this call is
The
coming in.
drug part is the only part that can come in.
but Your Honor,
Yes.
but there's portions of that first part where they discussed that they were going to get ready to shoot back at them, shoot back at the opposition when they were going to come through.
and
So earlier in the call,
When they're talking about shooting up Big Nick's, is that this part?
right, so before,
And being surprised nobody got hit?
right, but D'Amico says we were getting ready to shoot back at them, but we thought but it ended up being the police and not the opposition coming. And so I think that that's important, that they were willing to shoot back at them if they came back through
Your Honor, this
And,
is,
through the
and,
location.
and to augment that, Your Honor, just to add a little to what Ms. Hilton just said, them boasting and bragging to one another, we would argue our statements used to obtain confidence between co-conspirators, and it is serving to up and maintain trust and cohesiveness among them, and to inform them of the current status of the conspiracy. And in doing so furthers the ends of the conspiracy, as Ms. Hilton.
Thank you. I
Thank you.
understand the argument. I appreciate y'all perfecting your arguments for the record. My ruling stands. So the drug part can come in, and that's the only part from that wiretap. Now, I have a note that the one above that, 502 or 512, there's a reference to a quay in that one also. And there was a question whether there needed to be 105 instruction, or there could be a stipulation that as to who that was about, if y'all know it wasn't. Yeah.
in your honor, I'll just add to that. My notes indicate that the reference to Quay is that he's locked up in that call.
Okay.
So that made it
So decided-
especially concerning.
Do y'all know who was being referenced there? Probably.
If they're talking about Quay on March 16th, they're always talking about Quattrez Marks. That is who was at 2380 Waters Road. There were outside of Mr. Garlington, Mr. Stillwell, and Mr. Farley was Quattrez Arnold. A young man who didn't get the K that's escaping me right now, one other individual. So every time at Waters Road on March 16th, they're only talking about Quattrez Marks.
All right, and so y'all are gonna enter a stipulation that says it's not either of these defendants?
We can't.
Okay. I mean, if it's a stipulate, would you rather it be that? I can't hear you.
I rather that it not come in because it's an assumption, Your Honor, that they're saying we believe, we think that it's Martinez
Well,
Arnold.
no,
And there's-
it's gonna be a stipulation that it's not either of these defendants.
And again, Your Honor, we intend to introduce testimony through Investigator Viverito who was at the house when she arrived, along with the responding officers.
Okay.
We'll talk about who was detained on that day.
So is it gonna be a stipulation that it is whomever Arnold, the Quay referenced in here?
Yes, that is Cortez
So-
Arnold. Yes, we
okay.
will stipulate that the Cortez Arnold, that there's, the Quay that they're talking about is Cortez Arnold.
So there's another Quay that's being referenced. Fair enough. Thank you.
Okay, so that takes care of that as well. Make sure y'all get that stipulation together before that gets played. All right, let's get this nested hearsay issue taken care of before we break for the day.
Judge, can I ask how inclined the court would be to entertain a request to do the nested hearsay? Not today, but on another day?
Why?
Because I want to make certain that we have our most cogent, succinct, and clear argument for the court, because we're going to get one go at it, and I want to make sure that we do it properly.
Well, hadn't y'all already briefed it?
Judge, we have briefed something similar. That's what we were looking for earlier. But I don't want to read a brief to the court. I just like to give about 4 lines to the court if I can, if the court would indulge us and allow us to just argue it on a different day. That particular one, because it has layers, and I want to make certain that we say it clearly and quickly.
I couldn't hear. Are we just saying, hey, I need more time because I haven't briefed it yet?
No, Judge, I'll be clear, and I'll say it loudly enough for everyone.
A civil rights leader, or that you would be able to add something to what's already in the news, and you are certainly welcome to report. It's not either of these defendants? Okay. I mean, if it's a stipulate, would you rather it be that? I can't hear you.
I rather that it not come in because it's an assumption, Your Honor, that they're saying we believe, we think that it's Martez
Well,
Arnold.
no,
And there's-
it's gonna be a stipulation that it's not either of these defendants.
And again, Your Honor, we intend to introduce testimony through Investigator Viverito, who was at the house when she arrived, along with the responding officers.
Okay.
We'll talk about who was detained on that day.
So is it gonna be a stipulation that it is whomever Arnold, the Quay referenced in here?
Yes, that is Cortez
So-
Arnold. Yes, we
okay.
will stipulate that the Cortez Arnold, that there's, the Quay that they're talking about is Cortez Arnold.
So there's another Quay that's being referenced. Fair enough. Thank you.
Okay, so that takes care of that as well. Make sure y'all get that stipulation together before that gets played. All right, let's get this nested hearsay issue taken care of before we break for the day.
Judge, can I ask how inclined the court would be to entertain a request to do the nested hearsay? Not today, but on another day?
Why?
Because I want to make certain that we have our most cogent, succinct, and clear argument for the court, because we're going to get one go at it, and I want to make sure that we do it properly.
Well, hadn't y'all already briefed it?
Judge, we have briefed something similar. That's what we were looking for earlier. But I don't want to read a brief to the court. I just like to give about 4 lines to the court if I can, if the court would indulge us and allow us to just argue it on a different day. That particular one, because it has layers, and I want to make certain that we say it clearly and quickly.
I couldn't hear. Are we just saying, hey, I need more time because I haven't briefed it yet?
No, Judge, I'll be clear, and I'll say it loudly enough for everyone. We are asking to be allowed to make this argument on a day different than today. That is it. Please.
And
Thank you.
the reason is?
And the reason is we would like the opportunity to make certain that our argument is as concise as possible. We don't want to be trying to read a brief and distill information. We have briefed a similar subject. We would like to respond more clearly than we believe at this point we would end up doing today.
Well, the state has already sent what they thought was the issue to the court, which was 2 pages from a brief that was filed when in November of 2023, maybe? No, 2022. And that was in response to Mr. Copeland's statement. So the state has had plenty of time to come up with this. And you know something, we've been asking since December of 2022 for the unindicted co-conspirators. They were supposed to have been given to us well over a year ago. And now we get in here and unidentified people are being identified now.
Dun, dun, dun. Talk your talk, Brother Harvey. Talk your talk, man. They're at it again. Dun, dun, dun. Dun, dun, dun. Go ahead, Brother Harvey. Let them know what time it is.
Well over a year ago. And now we get in here and unidentified people are being identified now as unindicted co-conspirators. And no, I object to any additional time because we got some unknown person referenced in this phone call. And I don't want to hear anything about, oh, well, now we know who the hell this guy is. Now we know who we're referring to. And now we know that this dude is an unindicted co-conspirator as well. And I don't even know whether it's a dude. So let me undo that reference.
Oh, no. Man, this dude is sounding like Rhodes. Shout out to Harvey. Undo the dude. It's the dudette, bro. It's all about the dudette. Do the dudette. Go on, Harvey. We probably even look alike. Let's see. Does Harvey look like Rhodes? What y'all think? Let's check him out. Check him out. What you think? What you think? Do your thing, dog. Bruce Leroy Harvey. Holla if you hear him. Go ahead. Undo the dude. Man, that's Rhodes all day. Kind of like that.
Who we're referring to. And now we know that this dude is an unindicted co-conspirator as well. And I don't even know whether it's a dude. So let me undo that reference.
And I apologize.
And the unindicted, the whomever it is that's known that you're referencing as Rel?
Yes.
Or what
Yes.
sounds like Rel?
Yes.
So Judge, I'm sorry. We got the 9:30 p.m. Monday 9/9 supplemental brief by Mr. Harvey. And we want to just address everything and be concise. That's all.
Okay. And you know, y'all have had this for a couple of years now, and you indicted it. You've had this wiretap.
All right. You don't need to be talking to her. So, I mean, I think your biggest sticking point is probably the fact that some of this is only coming through Rel. And we're probably gonna have the same issue we just had with UNC, which is unless you're gonna be able to tell us more, it's only this statement that is gonna be able to establish anything about, and obviously Rel is very knowledgeable about what's going on, or they wouldn't be talking to Rel about this kind of thing, but that's only the statement that establishes that.
So if we could be allowed at the same time that we address, that we provide the court the additional information the court said it'll allow us to do on that one, the call, or if we have to do it before, I'm just asking for an additional time to address the last call, just this last one.
Okay, so I haven't given you any additional time at this point to do anything about the call, right? That's out.
No, it was out. I thought that the court had said something about redacting, and if there.
Right. Yeah, yes, figure out a way to, yes. Okay, I'm sorry, I misunderstood you. I mean, honestly, I'd like for us to do, what do you want, to just skip over it and move to another one?
Yes, if we can, and then come back.
Well, we certainly have 3 more pages to get through. Have y'all looked to see whether you really want, or you really feel like all of what's in this is necessary to establish different issues? I'm sorry, yeah. It is 3 pages. Have y'all done that yet?
Oh, I'm gonna be offended by that. Hold on now. Like Brother Harvey said, we done had this for years. We indicted this. Don't be asking me if we've had a chance to look at and see if we really want something. If it's before you, it's because I said I want it. You think I would put something in front of you that I hadn't even read? Who do you think I am? How insulting. You asked me if wait a minute. You asked me if come on now. I'm always prepared for court. As if I've even taken the time to read through something. If I really want it or not. What's wrong with
I mean,
you?
honestly, I'd like for us to do, what do you want, to just skip over it and move to another one?
Yes, if we can, and then come back.
Well, we certainly have 3 more pages to get through. Have y'all looked to see whether you really want, or you really feel like all of what's in this is necessary to establish different issues? I'm sorry, yeah. It is 3 pages. Have y'all done that yet?
Could this court repeat the last part?
Yes. So we still have 3 more sheets worth of this printout that you gave us, which is probably 10 calls or so a sheet. So maybe 30 more pieces of a call. Have y'all taken a careful look at that to see whether you really need all of this to establish the issues in the indictment? Because, I mean, this is going to take a long, long time to get through.
And so obviously, Your Honor, we are trying as the court, as we go on, to pare down where we can, as much as we can, but at the same time, keep defense apprised of things that we may use so that there's no argument that we didn't, but we can look at it some more.
I'd like for y'all to start making some decisions about, oh, we're not going to use this. So have you done that evaluation yet?
We on a lot of others, these are the ones we said we wanted to use. So yes, we can do that more. And as it relates to these that the court has in front of it, Your Honor,
Hold on, Miss Love. Let me help you out. Paige, There are times when we can pare down, and when those times come, we have done that, and we will continue to try to do that. But the junk that's in front of you right now is the junk we rolling with. We representing what we got to represent. There's people depending on us. My job is dependent on this. So you know what? Be chill. Because the way I look at my watch, your involvement in the back and forth that we do with you, it's not really saving time. I got calls here. You said I got 3 pages, 10 calls, 30 bits and pieces. Right. So that means the call might be what, 5 seconds? You gonna spend 15 minutes arguing with me every day about this stuff. Could have played the junk and been done with it. Okay. I tell you what I'm gonna do, Paige. You go through the case. You decide what it's going to take to convince the jury so we can convict everybody in this room. And then that's what we'll roll with. No, for real. Because I know that's really what, make you happy, give you something to do at night. So I want you to take all the evidence, strip down however you want. I mean, if it only takes one more day, cool. But whatever you feel is appropriate for us to get the convictions we need, that's all we'll roll with. Nothing else. Hook us up. Don't act like you don't know who Fani is. Don't act like y'all ain't got a way of, putting this together for us. Allegedly. Then we ain't got to go through this, Paige. Hook us up.
We'll give it another pass.
Okay.
We'll give it another pass.
Appreciate that.
Does the court have another day because that we can just, or do you
Have
just want us
another
to send the
non-jury
one
day?
to us?
Oh.
Yes.
Can y'all get that done by Monday too? Or no?
My team is saying we're gonna.
I'm asking.
Say no. You know you got stuff to do this weekend. Stop lying. You know you got stuff to do.
My team is saying we're gonna.
I'm asking.
If we could have a couple more days, but if we have to, we will.
Get it. We're not going to be able to discuss it next week anyway. So get it.
This is what I'm talking about. Put me through all that stress. And you can't even discuss it next week anyhow. Paige, you a trip. He's a straight up and down trip. Just so you can be saying something. So you can make me feel like you got some busy work. I don't need no extra work. I'm already behind. That's gonna make you feel better to give me a deadline that's not even relevant? There's all kinds of stuff we got to do right now. We're behind and we have to try to have witnesses for Thursday, Friday that we're not ready for. Okay. We're not ready for what's coming up tomorrow with the jury here. We're not ready. And then somehow there's next week that we're also not ready for. But we can't get ready because we have this other thing we got to do for you by Monday because that's just the day that came out of your mind somehow. And now you see the pressure we're under, but so what? Because you're not even going to get to it next week anyhow? Oh, you playing with me. Okay. Write that down. Write that down. Because the next time you ask me something weird like that, I'm just going to let you know. You do it. If it's so easy, you do it. Do the homework for me. I'll hook you up with some extra, I'll give you my dessert in the lunchroom. You get extra dessert. Hook me up with the homework. You do it. Appreciate it. Playing with me. Got me stressing over here and you ain't even gonna get to it next week.
If we could have a couple more days, but if we have to, we will.
That's, I mean, get it, we're not gonna be able to discuss it next week anyway. So
And then next.
get it done
So,
by the 20th.
Thank you.
so we're not arguing today?
Thank you.
I don't know whether we're going to. I
The
don't know.
20th.
We're not gonna argue the other ones, but,
You know,
there's other stuff we can do.
No, I meant the
The,
call 2119.
We're not gonna play 2119 prior to the 20th, so we appreciate that.
so, Mr. Harvey, I guess that your brief that you filed is so impressive and intimidating that they want some time to be able to respond to it.
Just agree to it because it's right.
Word.
So, have y'all gotten together yet on, Mr. Steele made us all a nice chart of where he thinks the evidence, the status of the various exhibits is. Have y'all been able to look at it and see where there is any kind of discrepancy in what y'all believe?
We have been looking at that. We've not done that joint effort, but we've been comparing Mr. Steele's chart with what our chart and what Ms. Weaver's is.
And where are y'all on that?
We're checking with our team member that's doing in the office now.
Okay, because had I walked in here at 9, dealt with the 2 Rule 22s and then said, let's hit the exhibits, which I told y'all by email several days ago is what I wanted to do today, would y'all have been ready?
We had that person over here
Hmm.
to be arguing that.
Okay, so that answer sounds like,
Master exhibit list, Your Honor,
Okay.
and then we can forward that we believe is up to date. And we can take some time, over the next couple of days to go over that with any designated person from defense, but we can forward the master exhibit list that we have that we believe is.
all right, y'all exchange that and copy Ms. Persfield as well. And then y'all get together to narrow down where there might be disagreement on the exhibit list. Yeah, because it's gonna be a bear and we can't just put it off until the end. We need to be doing this a few times as we go along. Okay. So, y'all, Mr. Ryan's crowd is gonna get together on whatever else that evidence might be and where there might be disagreement.
It's going to give us a list of some they narrow down, we'll have conversations based on that.
Okay. All right. And y'all are both gonna get me briefs by Monday, I think is what I said on the what was it? What did I tell y'all to brief me on? Anybody know?
I believe we were supposed to. Yes. Over, whether or not
It was
over
something
X.
else. Yeah. Well, somebody wanted to do that a long time ago and never did.
The other one was whether or not an overt act not listening indictment could solely be the basis of a conviction on count one.
Okay.
No. Yes, that's what was.
overact
uh,
is not listed, not a count chart, but an overact not listed.
No, they haven't yet. That's what I would like for them to do.
Okay, that was the Monday one.
That was one.
Okay.
Judge, with respect to that, would we be able to wait for the state's brief and then respond in kind if they're able to find that? Versus us just arguing what the Constitution says to begin with?
Sure, you can wait on that.
Thank you.
And then, okay, I guess if a prior conviction, which Mr. Ryan's murder conviction is alleged to be an overt act, were y'all gonna brief me on whether and how and if that needed to have any kind of a limiting
I think that would be a
instruction?
smart thing to.
Or was I just writing that down on my own as an issue?
No, I think that we had, earlier
Okay.
today, we had said, that his conviction, that there should be a limiting instruction as to his conviction. We had not, fleshed it out or anything, but
Okay.
I think it does bear some addressing.
I think so too.
Your Honor, again, and I'll do whatever if you want to brief, but I can't imagine a limiting instruction to cure. You know, I'm on trial with Mr. Ryan, and to have this jury be told that another jury in Fulton County found Mr. Ryan guilty of murder, and that his overt act, because you're dancing, the court's going to tell the jury to do this dance because, okay, don't use the prior conviction against Mr. Williams or anyone else of the jury because it's hearsay. But you can use it against Mr. Ryan somehow. But then it's an overt act against Mr. Ryan. And if Mr. Williams and Mr. Ryan are in a conspiracy, even though Mr. Williams is not part of that overt act, you can use that evidence against Mr. Ryan to find the overt act, and therefore Mr. Williams gets convicted on that piece of evidence. I don't mentally understand how you're going to
That is
do
the formula. That's I'm telling you, the power of this doggone RICO junk, y'all. Brothers and sisters, this stuff is nasty. Nasty. That's the connect the dots junk we talking about. And again, this is the safety net. This is how the state can get away with this. They can be sloppy, unprepared, all of that. But they got this power of this RICO junk. We're connecting this, connecting that, blah, 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 blah. If the jury goes for it, psh, y'all hit. It's like that, man. Dirty, baby. Dirty. Yeah, man, it's a tough game. All the way around. It's a tough game.
that evidence against Mr. Ryan. Against Mr. Ryan, and if Mr. Williams and Mr. Ryan are in a conspiracy, even though Mr. Williams is not part of that overt act, you can use that evidence against Mr. Ryan to find the overt act, and therefore Mr. Williams gets convicted on that piece of evidence. I don't mentally understand how you're going to cure that.
The determination is going to be made separately as to each defendant, whether they participated in those.
And Your Honor, I think that the
Right,
conviction
so-
is.
Whoa. What did you just say, Paige? I think you just said the wrong junk. That ain't. Nah. Hold on, Paige. Say that again.
On that piece of evidence, I don't mentally understand how you're going to cure that.
The determination is going to be made separately as to each defendant, whether they participated in those.
And Your Honor, I think that the conviction.
Right.
Yeah, I heard you lower your voice there. You ain't sure. No, you ain't sure. It ain't that simple. They can decide certain junk about the other people with the other counts, but that count number one, the RICO, it all links back to that is the state's hope. And once they connect those dots, then no, count number 7 or 935 that so-and-so did, no, I may not be guilty of that particular, but number 1, if she connects these dots, I'm still done. I'm still serving the big prison time because of number 1, the RICO, the first charge. So that's the whole point, that it does matter, because if homeboy did something, then the state can just say that it was in furtherance of this full organization. It's like, okay, yeah, he did do that. That's the whole point here. If Little Rod is actually allegedly guilty of some other junk, then that's one piece of the puzzle. Then you got brother Mounk Tounk, who said they did the drive-by in to do something to such and such and such and such, to let people know they wasn't no chumps and all of that. Okay, so see, you starting to build up these things, people doing stuff. It ain't just about a girl. It was about this with Professor Woody, and they had a beef with If Gang, or allegedly this and allegedly that. Okay, and we wearing the clothes, and we got the hand signals, and we got us on wiretap saying this and that, and we all love each other, and we this and we that. This is to connect the dots. Then no, I'm not guilty for count 937. But I'm a part of this conspiracy thing, count number 1, which means I'm still in prison. No fun. Get it straight. Get it straight. Come on, Paige.
You can use that evidence against Mr. Ryan to find the overt act, and therefore Mr. Williams gets convicted on that piece of evidence. I don't mentally understand how you're going to cure that.
The determination is going to be made separately as to each defendant, whether they participated in those.
And Your Honor, I think that the conviction
Right, so-
itself, the issue of the conviction, not the act of the murder, not the evidence or proof of him having convicted the murder, just like we've had to present evidence of other overt acts that were external to the conviction itself.
And you're presenting that evidence anyway, that you committed that murder.
Right, yes, Your Honor. And so the conviction itself, and by conviction, I mean the certified isn't the overt act, it's the actual murder that we are putting up evidence of, that we.
Right, but you're also wanting to put in the certified copy of the conviction of Mr. Ryan for that overt act, right?
Right, and that's what we were discussing with the limiting instruction.
Right, and so there is a danger, or it gets complicated about how to tell the jury what they can do with that evidence.
And Your Honor, I think.
And I hadn't looked at the two, cases that you cited yet, the 14 F3rd 881 and the Toko.
More and more, it's just clear you don't know what you're doing. Paige, more and more. I mean, you don't understand the basics of the RICO. Again, you can't just be so speedy. I'm not saying this stuff is not complicated. What I am saying is that don't come in here trying to run 1,000 miles an hour. Slow your butt down. Slow your butt down. That was the whole point of when we started falling off with this chick, because you're moving too fast and there are other things at work here. And again, I'm saying, remember how we first said it. We have respect for these people in the room. There were too many intelligent people who have been fighting with this information for years, struggling with this information, and they are still learning every day and digging in every day. So how you gonna just come in and fly in the face of all that and just speed through all kinds of stuff? That wasn't even us saying, Rhodes, we are so deep. Rhodes, we are so in tune. No, we were saying, have some respect for the fact that these cats are in here every day going through the intricacies of this madness. It's got to be deeper than it looks, because they're still racking their brains trying to get it right, trying to free their clients, trying to fight for justice. This is a major deal with lots of pieces, lots of history. and incredible ramifications. So no, Paige, if you don't understand how it still needs to be presented to the jury, then that goes back to what Rhodes was also saying. That if we get to that point where Paige Speedy Whitaker is reading those jury instructions, like how she ran through and read 1,000 miles an hour about that jury pool day when she was like, hey, can you forget or not? Okay, forget about it. You have any problem forgetting? Okay, cool. When she runs through and reads all fast like she does, reads through these jury instructions, she's not even clear right now how to present it in her own mind, let alone present it to them. And this is what I'm saying. This is the tightrope. How is the jury supposed to understand? And again, once they do get an instruction, if they do hear that one part, which is, hey, forget about everything else though, but if this dot connects with this dot and that dot connects with that dot, then they are all guilty of count number 1. If they hear that much and they understand that much, and the state's proven that there is this group that's an illegal street thing that has allegedly done these things in furtherance of these things, et cetera, et cetera, et cetera, and there's a pattern of et cetera, et cetera, et cetera, then boom. Yep, y'all butts in prison for the conspiracy, count number 1. All y'all. And then you go from there. Now you just start adding time from there. That's how crazy this is. So what Paige is doing right now is demonstrating she's not abreast. She doesn't have the heavyweight understanding of how this all works, which is okay if you were digging in from day one with this stuff versus just firing off stuff, cutting people off, not listening, acting like you were diesel when you weren't. You solar at night with no battery. You school on Thanksgiving. Rhodes.
What they can do.
I mean, but it's not cool for justice is the point though, okay? Really. It's not cool, man. It's not justice. You know it and I know it.
With that evidence.
And Your Honor, I think.
And I hadn't looked at the two, cases that you cited yet, the 14 F3rd 881 and the Choco 200 F3rd 1. That was you, right?
Yes, Your Honor. That was the state's cases.
So maybe those will elucidate it somewhat. I don't know.
Anyway, I just want to follow the court and aid the court if we can. So whatever I need to do to write, but I think that would be very prejudicial against.
And that's the danger is it going to be, is there a way to correctly limit it? So
I think
I need some
more, we
something on that would be nice as well.
Yes, Your Honor.
All right.
And I think we asked for just some additional case law, not in group form, possibly about prosecutorial meetings.
Okay.
Those were my notes.
Yeah, I mean, if you wanted to provide that.
And
See, man, you got cats like Lil Rod, allegedly, bruh. You got cats who actually have been to trial and lost, right? According to what we hearing, right? Lil Rod, the homeboy is trying to get the appeal going right now, but he's already been convicted of the big M. Homeboy sitting right over there, little man over there, right there. Homeboy that be chilling back there with Miss D. Williams, right? Well, he up here today, little homeboy. Yeah. They already found, another jury's already found homeboy guilty of the big M. Right. So, yeah. Of course, Love wants to bring that and say, look, it's not just that he's charged like some of these other cats, charged with something. He's already been found guilty of this thing that we're saying is connected to this other thing. Whoa. Somehow, some way. That's what they want to be able to do. So, yo, you see? Good Lord. But the jury's just going to forget all that and be like, yeah, all these guys, they love each other. All these guys, they hang with each other. But no, they didn't do anything because of each other. They were all just on their own. Everything was just on their own. But then the wiretaps, they talking to each other. They hanging with each other. They surround each other. They, you know, they're in jail and they're calling each other. All these things. But nope, they didn't do any of these acts on behalf of each other or on behalf of the unit. That's what the jury's got to be like. Yep, they was all on their own. Word. Okay. Or another possibility. I mean, there are a couple possibilities, but another possibility is, well, it was a separate YSL. It's a whole nother YSL out there. And so, yeah, they were doing it for that YSL. A whole different one. Not the music label YSL. It was a whole different one. You know what I mean? The jury's gonna do that though, because Miss Love, you know where she's trying to get it at the end. If they get that far, closing statement, she's trying to tie it all together. We can go back and listen to her opening statement someday if you like to, brothers and sisters. I mean, she's tied it all together. Remember, she came with the Kipling. She came with the Jungle Book. Oof. That has other problems. Rife with problems that she did that, but okay. Call Lil Jeff the leader, king of the jungle. These other cats just, you know, wow. Yeah, her doing the jungle thing is rife with problems. But that's also letting you know she's trying to bring it right there. She's trying to take it right there. She's not giving respect to anybody's individuality. It's about the unit, the herd, if you will, the pack, if you will. Lord have mercy. Huh? All right. Yeah, it's a tough situation.
And then you'll get me the hard copy of the in-camera material by Monday also. My first thing Monday.
Right. And when we're discussing the prosecutorial need for the intrinsic acts, we're looking at it through the lens of.
I mean, I don't need further evidence on that.
Oh.
I mean, not evidence, further case law on prosecutorial need. If y'all want to come up with some, great. But yes, that is exactly what I did want further evidence on, was could y'all find something that more factually aligns with your situation? And obviously that one, y'all were going to file at the same time because you can find case law that factually aligns and says, no, it's out. And just to flesh that out some more, and it being either admissible or inadmissible, because it either does or doesn't complete the story of the crime of the gangs or the crime of the RICO violations, or, you know, be the same kind of series of events as that. Because those are the only two that it might come in under.
Right, it has to, right.
Okay.
So just making sure that the cases that we bring to the court's attention addresses that.
If, yes, ideally, that would be wonderful. All right. Anything else we can do in the next 15 to 30 minutes?
Can I just get, I ask every day, want to know what files to bring
So,
tomorrow.
in terms of witnesses?
Yeah, if it didn't change, that's fine, but I know that the
So,
state said.
I think y'all said Pitts, Latner, Turner, Bell, Hill, Jinks, and Thorpe. I may have that one wrong. Jinks, was it Jinks or Jenkins? Jenkins. Is that still the plan?
Yes, for the upcoming 2 days.
Couple of days, yeah, okay. And then we'll talk again on Friday about what'll come up next week.
Thank you, Your Honor.
All right. Anything else?
Not, if it matters to you, other people spoke with the sheriff, and we are going to.
Okay, yeah, I didn't know where exactly y'all were going, but somewhere that gives y'all a little bit more room considering the number of people involved. Oh, right. I'm sorry, I didn't mean to just point at you. Miss Borden. Yeah, come on up to the podium.
I want to say thank you, Your Honor, for allowing me to come back up again.
Sure.
And I'll be real brief. I just want to share something to you and also on the record.
Okay.
I appreciate being granted the access to the camera pool, and I just want to respectfully express my concerns that that solution does not fully align with the principles of transparency and equal access. The decision to limit the media coverage to a single camera controlled by a pool, which restricts the diversity of perspectives and it raised concerns about control, suppressing, and also withholding crucial details that can be caught by several angles. And I know earlier, I think I might have shared, I am a civil rights leader. I'm also a noted and awarded community advocate for the state of Georgia since 2009. The Rule 22 provision was designed to ensure that the public and media has open access courtroom proceedings. And it is not to be limited to a singular source because that risks tampering with the spirit of that rule. By only allowing one feed, it is inherently biased. It ends up being biased with that coverage.
Are you reading from a case or are you just reading?
No, I just take some notes. I didn't want to spend extra time and I'm almost
Okay,
done.
I mean, so this is just your position. It's not case law, is
I
it?
do have some case law. I got two of them.
Okay. All right, go ahead.
So it assumes that one viewpoint is sufficient for capturing the full scope of the trial. It's essential that different media outlets are allowed their own access so the public can be provided with a fair and transparent view of all proceedings. So I am asking the court to reconsider this limitation and the transparency of the Rule 22. So when it comes to, for example, O.J. Simpson trial, also I was a part of Derek Chauvin trial. We were permitted live streaming to ensure full and unbiased representation of the proceedings. If you look up Press Enterprise COV Superior Court, 1986. Also Richmond.
I don't know how to look that up.
Oh,
from
I'm
what
sorry.
you just said.
Okay.
Do you have a site to a reporter, like a case reporter?
Well,
It's usually like numbers and then a book and then some numbers again.
I didn't, so basically I pulled it. If you was to type in Press Enterprise COV Superior Court 1986.
COB?
Press I'm sorry.
I got Enterprise.
C is in Charlie, O is in Oscar, V is in Victor.
V.
Yes,
okay.
V is in Victor, Superior Court, 1986. And I have another one.
What state?
Wait a minute, this is in the state of.
I mean, I can
Wait a
try
minute.
that, but I don't think that's gonna bring anything up for me. But anyway, what's the next site?
Okay, the next one is Richmond Newspaper, INC versus Virginia Supreme Court. And I also want to share that the restriction of the live streaming serves a compelling enough interest to warrant limited media access to a single perspective. Again, when it comes to civil rights leaders, right now, I don't see any other civil rights leaders here. Also, when it comes to community advocacy.
All right, well,
I
Mr.
apologize,
Steele feels
Mrs. Bryant.
himself to be a civil rights leader.
So I do want to go on the record, so I have just as much vested interest as the defense team. And I did look at the media room, what is required, I do not have. So therefore, I would ask the courts if I can bring a computer into the courtroom. I don't have to have my phone, but just a computer to do it physically in here. And
To do what?
I'm sorry,
physically?
to be able to do my notes, also to do live like commentary from my computer. And I'm also asking the court to uphold the First Amendment protection of public access.
All right, there is full public access. Anybody who wants to can watch this trial. It is being live streamed with a pooled media of at least 6 different news organizations. It is also being live streamed by an individual who is pooling with another individual whom you are welcome to pool with. And so you can do that as well. Okay. So, then are you saying at this point, you just want your computer in here so you can do live commentary, but you're okay with not filming it because you don't have the capacity to do it from the media room?
Yes, Your Honor.
Okay.
And also, I would like to, I know I brought it up earlier, I still would like to submit to the courts. Maui Davis of Davis Bozeman Law Firm did a letter. Also, Channel 11, I work closely.
Oh, yeah, I mean, and I said before, I'm
Okay.
happy to, and
I
I
would like
know
to
Mr.
submit.
Davis and happy to, but again, I don't not believe that you are a civil rights leader or that you would be able to add something to what's already in the news. And you are certainly welcome to report on,
Okay.
everything about this trial.
So in there also is a letter from DeKalb, Mr. Robert, he was the DA, DeKalb County.
Yeah, I know him as well.
Also, Channel 11, I work closely with their investigative team. They also did me a reference letter as well.
Okay. All right. Yes. Yes.
I just wanted to, this young lady referenced Richmond newspaper,
Thank you so much.
Virginia, and I believe the site is 448 US 555. from
I
1980.
thought that was a pretty big case.
so much.
I was familiar with
Press-
that.
And Press Enterprise is 464 US 501.
Okay, thanks. So, yeah, those numbers and then letters and numbers. So, I mean, the title.
Shoo. Shout out to Brother Sharp. Shout out to Brother Harvey. Sounded like those are two brothers that gave the sites for the sisters' cases. Shout out to Sharp and Harvey. Word. That was a cool move. Deserving of a replay. Yeah. Shout out to them brothers. Cool move. Cool move.
Team, they also did me a reference letter as well.
Okay. All right. Yes. Yes.
I just wanted to, this young lady referenced Richmond newspaper
so
v.
much.
Virginia, and I believe the site is 448 US 555. from
I
1980.
thought that was a pretty big
Thank you
case.
so much.
I was familiar with
Press-
that.
And Press Enterprise is 464 US 501.
Okay, thanks. So, yeah, those numbers and then letters and numbers, that's how we lawyers look up cases. So, I mean, the title's nice, but it's the numbers that we actually need. So, okay. And you know, what would you need to do it from back in the media room? Is this,
Just be able to plug up my computer and that's it.
so you're not worried anymore about being able to film?
No, I could make everything work from my computer.
Okay. All right. Well, I mean, I just gave somebody else the ability to do that. So I will revise your Rule 22. I don't know if I think it might have already been emailed to you, but
Yes, it
we'll
was.
withdraw that one and do another one.
And just to make sure I'll be able to
But
come into
again,
the
y'all
court.
are gonna have to fit in the media rows that are available here in court. So it might get pretty, I mean, sometimes there are only a few people here. Sometimes there seem to be a lot of people here, but, and, okay,
Thank you, Your Honor.
thank you. All right, anything else? Well, tomorrow is your next court date. Is that what you meant? Or no, the jury's coming back tomorrow. Did you mean when are we gonna have our next non-jury date? I don't really know. I'm thinking we could. I don't know, possibly sometime the week of the 7th, later in the week. But if we need one before then, or if we need one or two before then we'll have to fit those in. I mean, I'm planning for us to have 2 full trial weeks for the, next 2 weeks of September, but do y'all think we're gonna need 1 or 2 non-jury days?
I don't foresee that, not with how far out the issues that we still have.
Okay. All right. So then we'll plan to do full weeks for the next 2 weeks. And then maybe sometime the week of the 7th, we might have a non-jury day or 2. And if not, I mean, certainly sometime close thereafter. Okay.
Thank you. And Judge, one
Yes.
last inquiry. The matter that the court brought to our attention, from the sound of things regarding the request that we dealt with at the bench, no further.
I don't know what you, no, I don't know what you mean. I'm sorry, my memory just may not be as good as yours. I'm not quite sure what you're referencing.
May I approach with just any member of the defense so that I can
Yes.
deal with it appropriately?
right, brothers and sisters, just letting you know that when they break out of here, we're going to break out of here. So, again, you want to hear the things that we've had to say, the wonderful, powerful things that we've said, our great analysis. If you do say so yourself, you got to check out the stream. Shout out to Miss Mod. Shout out to Miss Mod. Check out those timestamps. We'll also have some videos coming up for you from today's stream. Some shorts and videos. What do you know about that? Yeah. Shout out to Miss Mod. All right, brothers and sisters. So when they're out of here, we're out of here. You have a blessed day. Look forward to seeing you soon. Take care.
Or anything else? Before we break for the day? Nope. Okay. Nobody else? All right. All right. Let's see. We have the jury back at 9. You know, considering that we've been together all day today, hopefully we won't have anything unexpected in the morning. Do you think we could just plan to convene at like 5 till 9? Okay, let's do that. See y'all tomorrow.